first exam. Got it? So you have more time to do your homework, first of all, and then and you have a week to study for the first exam. So we're gonna have lecture on chapter 7 today. On your exam, which will be 2 weeks from today, I want you to make sure you bring your Scantron, which is the 882-E form. It's in your syllabus. You do need it. It's green and white, 50 questions on the front, flip over, 50 questions on the back. You just do the first 50. For those of you that have been afraid to go through DSPS, make sure that I get all of, contact them, make sure I get your records by email. They know what to do, so that I get the testing materials over to you for that as well. Okay, try to do that a week before, because they will not do it if you just go the day of. Everyone clear? So take care of that. We're gonna go over chapter 7. Okay. Any questions with that? It just makes it more valuable for you guys with the time invested, because I really can't keep pushing it out another week. Missing that one day really kills you. So, okay. Let's see. Armando. Where's everyone today? Amanda all day.
Here.
Jaime Alvarez. Jake is here.
Here.
Jeremiah is here. Tony Cortez. Sarah Dominguez. Sophia Galindo. Alessandro Gallardo. Cristobal Garcia. Matthew Cuviera. Christopher Hernandez. Ethan Utah is here. Aranza is here. Jose Lopez is here, right? No. Nick, he's just next to you. Sorry. Isaac Marquise. Riley McGrath. Joseph Nieha. Lauren Maria. Pedro. Merlin Palacios. Jason Perez. Lily Ramirez. Emily Sanchez. Leo Sanchez. Joseph Santoyo. Natalia Serrano. Eli Vance. John Wagner. Tom is here. Sarah Evanes is here. Isaac is here. Julian Zavala. If you walk in, can check it, more than half the class is here today. But we still continue. Okay, chapter 7. We went through intentional torts against the person and property. We also went through all of the torts that you have to actually absorb for under negligence. Remember, you've got your 4 elements for negligence, your separate defenses, plus you've got your special negligence doctrines. Now we're going to get it into another area of tort law, which is called strict liability. Let's take a look. Strict liability. So just so you have an idea, tort law. Tort law, we have intentional torts, and we have negligence, and then we have lastly a very strict liability. Okay. You just have to look at it in the way that tort law encompasses 3 separate areas, but they're all actionable, which are civil wrongful actions that are violations against a private interest. Remember the distinction between crimes and civil wrongs. So these are just those areas that are civil wrongful actions that have occurred, and they all fall under torts. Strict liability has its own assessment, unlike the intentional torts. I think there's 13 that you have to know. On the area of negligence with the 3 separate special negligence doctrines, strict liability is going to be evaluated very differently. So let's take a look and see how it is evaluated. A couple of different areas. So within strict liability, we have separate areas we gotta know. We have abnormally dangerous activities, wild animals, and then we have strict product. So I'm going to whip through these two very quickly because they're not the ones I'm most concerned that you know. And I'm going to spend, obviously I want you to generally know these, but you really have to understand strict product liability. Let's talk about dangerous, the first step, abnormally dangerous activities, okay? First of all, let's examine the word strict liability. So many people have heard it. It's very, in a lawyer's world, strict liability is, if you're a plaintiff's lawyer and you have a strict liability case, you don't have to prove anything. You're already gonna be, like, the proof is there. We're gonna be trying to talk about damage. Strict liability is, listen carefully, it's liability without fault. So as a defendant, you're going to be liable even if you did everything you could to protect someone from getting hurt. So think of it this way. We're not in the area of negligence where you have a duty of care and you exercised as much duty as you could reasonably, or what if you're a professional, you just perform at the highest duty of care to make sure someone did not get hurt, which would be the plaintiff. We're not talking about that. This assessment is completely different. This assessment is, it doesn't matter what you did, even if you did the most you could to protect a plaintiff prospectively from getting hurt, that plaintiff still got hurt. Does this make sense? And you're gonna be responsible. There are 3 areas that, in that assessment, that apply. Let's look at the first one. Everyone clear where we're at? The first is called abnormally dangerous activities. There are certain activities by their very inherent nature that the court considers to be just super, super dangerous. That, listen to the way that it's processed. No matter who were to be involved in these, quote, abnormally dangerous activities, they're also synonymous with the word ultra hazardous, abnormally dangerous or ultra hazardous. You're gonna see those very synonymously used. Anytime there's activities that are abnormally dangerous or ultra hazardous, the court considers these activities that no matter who's conducting them, they're just gonna be very dangerous, and there's gonna be a very severe risk that no matter how much protection you use, that someone could get hurt. Based on the fact that these activities still have to be conducted, it's very unfair to put all the burden, if something goes wrong, on the people that conduct those activities that are necessary to get particular tasks done. So as a result, the court says, well, if you're gonna hire someone that is involved in this abnormally dangerous activity or this ultra hazardous activity, just simply because it is so risky that if someone gets hurt, we're going to charge the party that's involved in conducting that abnormally dangerous activity, as well as you that hired them, to be responsible. Does this make sense? It's just because the very inherent nature of the activity is so dangerous. And you don't have to know all of what those activities are. That's why we're not gonna spend a lot of time in this area. It's pretty much at this foundational level, it's anytime you're using like dynamite, TNT, explosives. How many of you have ever seen like a building implode with dynamite? You know, they show footage of it, especially when Las Vegas was being rebuilt, when they took off down the old Sahara, like basically the strip has been rebuilt. Everyone knows, I don't know, you guys were not born when there was the old strip, but the old strip was there and it was like when Las Vegas was cheap. Okay, I don't know what people think anymore, but it's, anyway. Bottom line, it was these buildings, they hired a demolition crew, for example. They put the dynamite on the building. I mean, this is a very dangerous job. No matter who you hire to do it, whether you do it yourself, it's gonna be dangerous, true? Something could very well go wrong and someone could very well get hurt. So, for example, if you hired someone to demolish a building and they get the city permits, they tell you the time that they're gonna push the button for the building to explode. They just go through all these particular channels to make sure that everyone's gonna be safe and it's gonna be done in the most proper or prudent manner. Let's say that all happens and you push the button with the crew, everything's set up, the building, implodes, but let's just say a little tiny piece of concrete, which could very well happen, flies off, into the street somewhere, and someone who's an innocent pedestrian walking by gets clunked in the head with this cement, you could really hurt yourself, okay? Bottom line, that person can sue not only the demolition crew, but whoever hired them, does this make sense? Under the area of strict liability, specifically in the area of abnormally dangerous activities. Again, what are the factors that the court looks to determine whether an action or an activity is abnormally dangerous? And again, they're gonna say, even if, and again, you don't need to know all the activities, but they look to, even if the defendant exercised, listen carefully, the utmost degree of care, the risk of harm is still quite severe, and they make that assessment, and they have a whole bunch of, pretty recognized activities that they consider abnormally dangerous. Does that make sense? Any questions on this? Okay, then we're gonna move to wild animals. I'm not your, the resources for what kind of pet you have, but check your HR Society, figure it out, okay? But please know this, there is in law, and it breaks my heart to say this because it'll make me cry that I'm actually telling you this. I lost my dog this year, and we had Maddie for 16. She every time I thought she was leaving, she's like that little time. She's a cockapoo, 16 and a half years, and unfortunately, the law considers my dog as personal property, and your dog too. That's sad, because I love my dog better than people, but it's the way it goes. Animals are considered personal property, especially your pet. But there's a category for animals, okay? You're gonna laugh. I'm not a cat person, but I love them. I just don't want them. I'm a complete dog person, okay? Of course, dogs. You people that have cats and tarantulas, and snakes, whatever, just let me know that you're responsible for it. If you have a wild animal, there's a whole category of just what we call not dangerous, just domesticated animals versus wild animals. I'm just gonna give you a general list of what the court considers to be a domestic animal. Your dog, your cat, even a rabbit, gerbils, hamsters, guinea pigs, and I really don't know any others, to be honest, I don't even know if you look up whatever animal you have. And then there's a whole list of what the court considers to be wild animals, which would be your, farm animals. Does that make sense? Pretty much all the farm animals go in there, as well as exotic animals, like people with birds, like parrots, tarantulas, all that stuff, the boa constrictors. I have no idea, and if you own one, do not tell me that just gives you the creepies. But that whole area, okay? Bottom line, you need to know, as an owner of a wild or domesticated animal, what your rights are if, without provocation, listen carefully, without provocation, your animal bites someone. Does that make sense? You gotta know, here's how it works. Wild animals, if you are with a wild animal, even those, a lot of people have, not a lot, I don't know a lot of people at all that have it, but it is very cute, the pork belly pig. You don't have those as little pets. How funny to see a little pig walking your house. Oh, okay. But believe me, I don't know. Animals are great. Please don't hate me if you're a cat person. They're cute. I just don't want one. I feel do you ever notice that cats are stuck up?
Yeah. Like a dog's gonna.
I just think dogs are just great. I don't care. They love you. And what's the purpose of a pet? I'm sorry. You walk in, it's not even a pet, it's a person's I'm so happy to see you even if you're in a cranky mood. Dogs are great. You should all get one. Okay? You should touch one. Cats, you walk in, you're here, and then you just turn around and walk away. You know what I mean? Whatever. Think about that. Anyway, did a big sale for doggies. This is really sad because it's true. I literally was gonna pull a day where I wasn't gonna come in because my dog, I'm serious, it was I could not control myself, and I knew she's been sick for a very long time, which is really sad. But she's supposed to only live for 11 years. She's I got 14 from her. Everyone feels sorry for her. But the thing with animals, is even within the canine group, which is my dog, like if you have a dog, there is considered your aggressive propensity, canines versus your like regular domesticated animals. A cockapoo is they're not aggressive, okay? My dog is scared of her own shadow, you know, she was, anyway. But then you have the dogs that are built for guarding, like a German Shepherd, like an Akita, like a Pit Bull, like Rottweiler, Doberman Pinscher. Do you see what I'm saying? These dogs are actually, they're made for protection and guarding. It's in their bloodline. So if you have a dog that has an aggressive bloodline, and it's, do the math, I'm not the resource here, just so for your own safety, understand if without provocation, you're taking that dog for a walk, and for some reason it snaps and bites somebody, does that make sense? The first bite for that dog, it sounds interesting, but it's true, would be a negligence bite. Trust me, you could be in a lot of trouble because the person, depending on the injury, they could, I don't know what they can do. You know, they file complaints and try to get your dog put down. It's kind of a lot. But if a complaint is filed, and typically it's filed within the city, that's how it works, they have noticed that your Rottweiler bit this person. So now it has a record. Your little doggy has a record, it's kind of sad. Okay, so it has a record of having a propensity to bite someone. So the second bite would be a strict liability bite. It doesn't matter if you have like a muzzle on them. Does that make sense? It doesn't matter if you took all precautions to protect someone. If without provocation, your dog inflicts harm to somebody else, it's a strict liability bite and you're guilty no matter what. The first time you'd go to court and prove the negligence, because does that make sense? But the second time, it doesn't matter. Got it? And if you have a domesticated animal, it's negligence. Does you understand? Like my dog, if you gotta prove everything, it's all negligence. Strict liability for all wild animals. That is no, like you take your pet llama for a walk, okay? And I don't know if you have a pet llama, but if you do, you're taking your pet llama for a walk, and without provocation, the llama somehow gets away from you and just bites someone, automatically that bite's strict liability. Does that make sense? These are wild animals. Any questions? John?
So with the, with all, like, the domesticated animals except for the aggressive dogs, it's just always gonna be negligence?
Well, I never say always in the court of law. I'm just generally letting you know that typically, without provocation, your first bite would be negligence. Just leave it at that, okay? Eli?
I have two. So, like, say you do get, like, if your dog gets strict liability, does it get put down, or what happens?
Sadly, it just depends on what the person's pursuing, like who the dog bit. They can, if it's like brutal, you know, this is really sad. This happened to my friend's daughter. She had to have multiple surgeries. She adopted a pit bull, and it was totally fine for a year, but then it just lost it, and it just attacked her. And she literally almost lost her arm. She had to have like multiple surgeries on her arm, and she had to put it down. See what I'm saying? The city just, she is a dog owner, and she adopted this dog, and it was really harsh, but, so I don't really know, because once the city has it, depends on the injury, does that make sense?
Yeah.
So, it just turns into its own nightmare. So it's just, I always say this, if you have a dog, my brother has always had like he loved Rottweilers, and they are so cute, especially as puppies, but you do have to train them properly. Does that make sense? An aggressive bloodline dog, I do not understand people that have these aggressive bloodlines dogs, but don't go through the proper training for them. You wanna make sure you always are with the proper, like, even the leashes have to be different. Does that make sense? You can't just like, go to, like, off leash, walking a dog. I think it's way easier to walk my dog off leash, even though I'm not supposed to, than it would be a Doberman Pinscher. Does that make sense? Or an Akita, but anyway, that's this area. Are we good? It's just more general knowledge. I'm doing this more to explain this to you so you have some foundational knowledge of it, but this isn't a big testable area. It's more just foundational knowledge. Got it? Jake?
So when the dog gets negligence and you get this slap on the wrist, like you have something on your record now.
The city would put it into the file. It's like a city, sadly, it's like your dog or animal is your, it's
It's your
personal
property,
property, it's
that's
like a
what you're saying.
property complaint.
That was my
Exactly.
question would be, so that would be tied to your name, specifically
Yeah,
as,
if the dog doesn't, yeah.
Yeah, got it,
Be-
okay.
You're the owner, yes.
good to know.
Wait, one more?
Yes.
Sorry.
I love you guys, cause you're dog people, I can tell, you're asking questions about your
Do
animals.
the rules still apply if a dog bites another dog? Like my dog bites your dog?
Oh.
It doesn't kill it though, like it.
I really, honestly, Eli, I wouldn't even know, because that I don't, I've never processed that, like, I just never learned that. It's personal property, biting personal property, it's really what it comes down to, and I really don't know. You know, I would just go on a leap of faith here, and this is purely, and I don't like to do this as speculation, just for knowledge. What I think would happen is because it's your property, if it's without provocation hurting somebody else's personal property, does that make sense? I think that's how the court would assess it, so I'm not, but I don't know. Jake,
Sorry. So,
what kind of dog do you have?
Well, the doodle.
Let's get, okay, really quickly, that's probably the next dog I'm gonna get, they're so cute, okay, go ahead.
so they have specific lawyers, tailored towards this thing or no?
No, if I was still practicing, if someone had a case, I could handle it, I would
Got
just
it.
research it. I just never had someone ask me to handle that case, does that make sense?
Sounds good, yeah.
I just didn't. It would be interesting, I know. I
That's
would
kinda-
fiercely be an advocate for the dog, trust me. So, you know, but, yeah. It happens, you know, stuff happens a lot, sadly, but I've never personally been involved in that type of situation. But I'm just explaining foundationally what goes on. Any other questions before we go to the big area that's very testable? Okay. Strict product liability, I added the word product in here because, and let's do this. This won't make sense unless I do. Okay, we got product liability, another heading. Okay, think of this, product liability just simply means you buy something, right? Got a product, it's not working, whatever, I call it defective, okay? It could be defective, something's wrong with it, okay? It doesn't do what it states, like the warranty says it's supposed to do. You can sue for your product that doesn't work under the big heading called product liability. That's the big heading, okay? Defective product, and you're suing because product liability, how much am I gonna get based on your product being defective? Because it hurt me, that product hurt me in some way. So that's the big area. I want you to understand how to break this down. You can sue for a defective product that approximately causes harm to you as a plaintiff under a fraud theory. What is fraud? It's an intentional tort. Right? Remember, misrepresentation, right? So think about this. Someone tells you this oven won't heat up past a certain amount. You buy the oven, it does, it burns you. Does that make sense? You can sue under a fraud theory. You could also sue for your defective product liability, under what's referred to as a warranty, breach of warranty. You guys ever heard of a warranty?
Yeah.
Okay, well, this would be a breach, which is a failure to perform, and we're gonna learn this on the next unit. Contract, it's a contractual theory, we haven't learned that yet. So we can sue on an intentional tort theory, fraud. We can sue under a contractual theory, where it's a warranty is like whatever the product represents it's supposed to be, and it doesn't perform as it's stated in the warranty, in the contract. So that's a different type of a way to get your remedy, is to sue under a breach of contract or a breach of warranty theory. We're gonna learn that unit next. Then there's another area, we can sue under negligence, which is another tort, right? That's that other area. But if you're gonna sue for your defective product for negligence, what you're gonna say is the manufacturer had a duty to put a better label on it. Does that make sense? There was not a proper warning. Based on the fact, they breached their duty to me, the consumer, the plaintiff, because there was no warning. I had no idea. Does that make sense? And this foreseeably led to me getting hurt because You should have warned me. Does that make sense? So you can pursue a product liability theory under what we call a negligence theory. Here we go. Now we can also pursue a product liability theory under strict liability. Here, you can say, the product's defective, the product's gonna cause my harm, defendant, you have to pay for the damages. Does that make sense? You're at fault simply because this defect existed and it caused my harm, and we're gonna talk about it. Do you understand what I'm getting at? These are just multiple ways of suing for product liability, and one of the ways, the new way that we're gonna learn is strict liability. Do you understand the roadmap of what we're doing? Yes or no? Does that make sense? Good. Isaac,
Could you explain negligence again, please? I'm sorry.
why don't you explain it to me? Because what are the 4 elements for negligence? You should have done homework for today, so what is it?
One,
Okay, well, remember, 4 little elements for a big tort, right? You need duty of care, breach of that duty of care, proximate causation, which is foreseeably gonna lead to the type of harm suffered. Done.
sorry.
That's that whole area of negligence. So you're really happy I'm doing lecture today and not going over the homework. Okay,
Yeah.
so please know that these are all, other than contract, which we're gonna learn, these 2 you should already know. Does this make sense? I'm just adding another way to recover for a defective product that causes harm. Everyone clear? Got it? Around that.
So to sue, you have to pick one of those 4 regarding product liability. Or
If you're gonna, if a defective product hurt you, and there was misrepresentation to it, and there was a contract, and you can put them all together. If it has to arise from one defective product, whatever fits, does that make sense? You can't force something if it's not there, but if there's a defective product and you don't have strict liability, maybe you have negligence, you see what I mean?
Yeah.
But you could have them all, that'd be great,
Oh.
does that make sense? Think about this, I'm teaching you not how to prove anything, I'm just teaching you the actual legal concept, because I'm never gonna say to you to be the lawyer in the test. Do you understand what I'm saying? I'm just saying, identify and see if you can apply it. But there's please know this, I appreciate your interest, I really do. It's so funny how students take when I'm explaining things to you, like I don't want to help you. I do wanna help you. I want you to learn in a very foundational way, and I'm trying to teach you how to apply a legal concept. So there's so much to unpack in law. I'm taking it so empirically because we're not in law school. Do you see what I'm saying? I'm teaching you what you should know about the law within the confines of how much you can know at this point in your life. Does that make sense? At this point of your life, I'm teaching this course and I can teach it to anybody. Does that make sense? Versus when you're in law school, it's a whole different situation. Do you see what I'm getting at? It's just different. So all I'm teaching you, please go back to this, is you get to learn a little bit of the law, right? But the processing of how you figure legal concepts out and how it applies to just ever-changing fact patterns is the money in this class. Does that make sense? It's how to apply what you're learning. Yes, you get to know the law, which is something that's great because ignorance of the law is not a defense. You should know the law. But more importantly, I'm trying to teach you how to take concepts and, like, when I go through the elements, how you can take it and apply it to ever-changing fact patterns. That's what I'm really trying to get you to establish. Like, for here, we've already learned what fraud is, right? We've learned that it's here, let's say you go to buy a product, right? They misrepresent, they make a false statement of material fact to you around stuff, right? You realize your judgment, it's not what it says to be, and I'm like, I paid that for that, and it's not even what it's supposed to be. You can sue for fraud. Maybe it had a warranty. It's not what it stated to be. Do you see what I'm saying? Then sue for a warranty. Obviously, let's say maybe you can't sue for negligence because there was no manufacturer duty. Does that make sense? But you have these two. Do you see what I'm getting at? You have to just evaluate, I'm just helping you understand how to process, is whatever cause of action you choose, you can't force it. Does it fit the facts for me to pursue an action based on you know what the concept is, does it work? Does that make sense? And you wanna go to court with the strongest amount of actions you can, because hopefully one will stick. Does that make sense? But you can't just throw in actions that don't fit. There's no negligence on the manufacturer, but there was fraud on the person selling it to you, sue for fraud. Does that make sense? You see what I'm getting at? Got it? Okay. All right, so let's talk about this last category of product liability, and it's the most, I would say, the more interesting one, because it's the one that's really highly publicized in the news. I think it's the one that you see a lot of attention drawn to with pretty much any type of product. When we're talking about strict product liability, I'd say that 30, not even longer than that, I don't even know, like maybe 50 years ago, 50, I don't even know. The law, there was no such thing as strict liability for products, okay? It was limited to what we call privity of contract. These are just terms that you gotta know. Let's put this down, privity of contract. I make it really simple. Privity of contract simply means a legal relationship. So when you bought a defective product and it caused you harm, the only people that was the parties that had to be plaintiff and defendant was the actual consumer that bought the product and the actual manufacturer that sold the product, seller and consumer, got it? That was it, that's what it was limited to. And it was only limited to what we call economic damages. What that means is, it was just all about the money. That's what you could get. That was based on historical law. Product liability is moved into such a level where, listen carefully, anybody, absolutely anybody, that is proximately harmed by a defective product that is put into the stream of commerce where the defendant did not make any substantial change to that product, and that product that proximately caused the plaintiff's harm, that plaintiff can sue as a winner under strict product liability. So it's pretty much anybody, let's repeat, that is harmed proximately by a defective product, and the defect had to exist in the product before it left the defendant's hands, okay? And that defect in the product, that product could not have undergone any substantial change not caused by itself, okay? And then that product had to proximately, which is foreseeably cause the harm to the plaintiff. So I'm gonna give you a little example, and this will put things into perspective, okay? How many of you have taken just JIVA's 5? Okay, well, that's another class that's an absolute requirement as a business student. You didn't take JIVA's 5? Like the rest of you guys haven't taken it yet? You guys are business students?
I'm taking it right now.
Okay, or you're concurrently taking it?
Yeah.
How many of you are concurrently taking JIVA's 5? I wanna see the hands up with, if you're taking JIVA's 5 currently and you've already taken it. Okay, there's still a few of you, okay. You're just knocking this one out of the way first?
Well, I'm in construction management, so I don't think I need it technically to transfer.
To transfer?
Yeah.
You do.
Well, I haven't been told then, so you're the
Don't
first.
listen to they. You have to figure it out by looking at the curriculum yourself. I say this to every student. How many times I say this? I'm saying this because I care, okay? Got it? Do you wanna listen to they, or do you wanna make sure that you get out of here as efficiently as possible, okay? If you're trying to get an AA from this school in business, I don't care if it's construction management, do you see what I'm saying? I don't care if it's whatever type of management. From an AA from the school or an AST for transfer, you gotta take JIVA's 5, you gotta take B-Law. Those are absolute essential. Then you can work on the accounting or whatever, you know, there's one for personal, for non-accounting majors, but you gotta take some form of accounting class. Those 3 aren't going anywhere. Everyone clear? Please know that. Please know that, John. Okay, so why I'm saying this to you, if you've taken JIVA's 5, and the only reason you should take it, not the only reason, but one of the primary reasons it's in your curriculum, it's the language, the vocabulary is necessary.
and that's it. It's not a tough class, I'm gonna be sincere. I know that a lot of people say that this is probably one of their tougher classes. Okay, it's not. Don't kill the messenger. Does that make sense? Everyone just wants to downplay about the person that's teaching the hard. It's like, I taught GBIS 5 before. I was everyone's favorite teacher, just say it, okay? And it's not because I was so likable. I think it's because the material was so easy. Does that make sense? I taught when I was teaching management classes, I taught a lot of management when I first started here. I was everyone's favorite teacher. The minute I teach law. You know what I'm saying? So, GBIS 5 though, I'm gonna say no matter who teaches it, it's not that tough of a class, but it's necessary because the vocabulary used is something that you will have to see over and over again, okay? And the reason I'm saying this, every single product that comes into your hands goes through what we call a channel of distribution. I don't know, for those that are currently in GBIS 5, have you ever heard of that? You haven't heard of that yet? Who do you have? You guys kill me. That guy.
I have this class, but it's an old guy.
Does he have like a mustache, like a Lorax mustache?
Yeah.
I know who you're talking
I'm not
about.
even going, I'm not gonna ask anything anymore. That's fine. I know who you're talking about, but
I don't know his name either. I'm trying.
It's
Is that the
Nick
tip of my-
Mullen.
Nick
Oh,
Mullen?
yeah, yeah,
That's it.
yeah.
That's right.
I'm so sorry, but you know the old guy. I'm like, don't say that to him. Okay, so, gosh, I just think you guys are funny. All right, here's my favorite drawing of cars, right? Okay, here's a brand new car. I'm gonna tell you what channels of distribution are. New car. You buy that new car from, I don't know, a retailer. Again, please know I'm not defaming any product, Worthington Ford, they're really good, I got my car there, okay, so, but look, we're gonna use them because, okay, so this is the retailer. The retailer gets their allotment of vehicles through a distribution warehouse, distributors. Who gets it from the cars that they get are from the manufacturer. And they put it together because they get it from like basically what we call component manufacturer. Okay, this is just a please know, I am sure I'm missing a lot of steps, but every single product that gets into you, the consumer's hands, goes through what we call a channel of distribution. Does that make sense? So I'm just hypothetically using a car as an example because it's something that people can kind of identify with pretty quickly. So here's the component manufacturers, like some people make the transmission, some people make the steering. I'm really bad with cars. Some people make the brakes, some people make whatever, you know what I mean? All the different parts that you put in a car, okay? And then the manufacturer takes those specialty parts and assembles your brand new, let's just say Ford vehicle. Everyone clear? This is Ford, okay, Ford company. Then all these beautiful Ford new cars go through the different distribution warehouses in different sites nationally, okay? Obviously you could do this globally too, but nationally. Then the distribution warehouses have their regions where they are in contracts with what? The retailers. Does that make sense? You've got Worthington Ford and different Ford areas all over. Do you see what I'm getting at? And then you come to the retailer and say, I want to buy a new car. And then you purchase the car from the retailer. Everyone clear? That whole system, there's a chain or a channel of distribution for absolutely every single product. We're talking from a notebook to a blow dryer to pens. Everyone clear? There's just to a computer to cell phones. It's just there's a process. Okay. Let's take an example for you to understand strict product liability. This is a simple way to do so. All right, so this is how your brand new Ford Mustang got into your hands. Your rich uncle died, gave you some money, you decided to buy a new car, okay? You're like, I'm sorry, uncle, that you had a heart attack. And you're like, with a smile on your face, I'm sorry. Okay, so got your new car. Jason, you're sick. So anyway, so you got your brand new car and got a weekend going up. You want to go to Mexico with some friends. You got 4 guys pop in the car, driving down the 5, brand new. And I don't know about you, but if you ever, like, my son goes to school in San Diego, if I go down there, everything's good until you get right to about like San Clemente and Oceanside. It's just, no matter what time of day you go, I don't know if you know, if there's traffic. It's like, you're just like cruising, you're like, okay, this is great. And also you're like, literally, that whole thing was 30 minutes. Do you know what I'm talking about? So that's happening to you. You're driving down, you're like, you see all the lights. You're like, what is going on? And so you start slowing down. You're just going with normal speed, putting your foot on the brakes, start slowing down, you're pumping the brakes a little bit. It's not stopping. You're like, what? Start like slamming on the brakes because you see cars that you're like, what? Worst thing happens. You slam on the brakes, the car didn't stop, it rolls into a few other cars. Everyone clear? There's a 5-car pileup now. Everyone's got damage and injury. Everyone clear? Question, class. Who are the proper parties to sue in a strict product liability lawsuit? It's a brand new car, brakes aren't working. Who can sue if you're suing under the theory of strict liability? Okay, Joseph,
The dealer you got it at.
that's not the plaintiff. I'm asking
Oh.
who can sue.
Pass.
Hmm?
Pass.
Don't you think if it was your car, like, this is not like rocket science, people. Joseph, you're in the car, it's your brand new Mustang, the brakes aren't working, you get hurt, so does everybody else. Don't you think you're gonna sue?
Well, yeah.
Well, that's what I'm asking you, okay? So yes, you're gonna be a plaintiff. Is there anybody else that's going to be a plaintiff in this lawsuit?
The other people that got like damages from.
I agree with you. That's all I'm asking you. Who are the proper plaintiffs to sue? Every single person that is hurt, that got hurt by the fact that your brakes didn't work in this brand new car. Do you see what I'm getting at? Those are who we call proper plaintiffs in this lawsuit for strict product liability. Now, Joseph, I'm gonna ask you, who would be the defendant? Who would you be suing?
The dealer.
Okay, I agree. Anybody else? So you wanna sue the dealer?
You sue the manufacturer as well.
Is that what you were gonna say, Eli? Okay, I'll give that to you. Anything else? Isaac?
I would sue the component manufacturer too, because the brakes are a component of the car.
Okay, I'm just checking what you think. Anybody else? Okay, here's the deal. You bought a brand new car, right? Thought it was fine, like you were driving it. It seemed like it was working. All of a sudden, you're on the freeway, the brakes don't work. Does that make sense? That defect existed when it left the retailer's hand. Okay, we didn't do any facts to change that, correct? So you didn't manipulate the car or anything with the brakes, and you didn't do anything. So here, there was a defect that existed that here the defendant put into the stream of commerce. You didn't do anything to change or materially, substantially in any way, change or manipulate that product. And approximately, the brakes aren't working. It is the reason why everyone got hurt. Got it? As a result, everyone that got hurt from that defective, when you try to put on that defective brake from that product, that defective car, is a proper plaintiff to sue. But strict product liability lawsuits are so intense because they're the big money lawsuits because they're deep pockets. You're gonna be able to sue the retailer, the distributor, everyone, anybody who makes that product and makes a penny off of it is a proper defendant. Does that make sense? Because nobody is trying to put a defective product into the stream of commerce because it's costly. No one's thinking they're gonna make a product that's gonna kill you. Everyone clear? So, did everyone make a penny off of this sale? Yes. So everyone's gonna be charged as a proper defendant. That's why there's such expensive lawsuits. Deep pockets, because think about the social responsibility here. We've moved way past just suing the person who's the manufacturer. Before, it would have been for the manufacturer and you, and it would only be for economic damages, for like damages to the car. Does that make sense? If you're gonna sue under product liability. But now, you can sue for personal injury, anything. Does that make sense? Based on that defective product causing you harm. It can be financial, as far as economic, as well as personal damages. It can go anybody. It doesn't have to be the consumer. It can be the cars that you hit. Does that make sense? These are all proper plaintiffs, and you want to make sure that you sue everyone in that channel of distribution, because it's not up to you to figure out whose mess it is and whose fault it is. All you know is you bought a car, it didn't work, it caused you harm, you're gonna sue. Everyone clear? Make sense? Let's change that. Let's say that you bought the car from the retailer, but you wanted to, have, I don't know what, you guys are gonna laugh, like zoop up the transmission, I don't know, like make it go faster, I don't know.
Zoop?
So, what? I don't know, you take it to your own shop, don't ask me. Acme, like Roadrunner, okay? You take it to some store, a mechanic store, and they just really manipulate the car and make it go faster. I don't know, people, I teach business law, okay? So, here we go. So you take it to that place, and then it goes back here. Everyone clear? You get the car, and now it's like, the transmission's better, it's just faster, and what have you. The same thing happens. Unfortunately, because it was manipulated, does this make sense? You've actually really lost your big deep pockets. Does that make sense? So you would have to resort to suing under, I don't know, what we call negligence. Does that make sense? You see what I'm getting at? Yes or no? Okay, so you really have to take a look. If it's being manipulated, you lose, you know, that situation. So, strict product liability, again, no longer do you need what we call privity of contract, which means just to be in that legal relationship between seller and buyer. It's no longer necessary. A proper plaintiff is absolutely any person that is harmed by a defective product that's placed into the stream of commerce, where the defendant had that defect exist in the product and it did not undergo any substantial change not caused by itself, and that defect then possibly caused your harm, you are a proper plaintiff to sue, and pretty much every single person in the channel of distribution is a proper party to be sued as a defendant in a strict product liability lawsuit. That's why, like, all these cases, you know, way back when, remember with Firestone, no, it was Goodyear. They had the Goodyear tires on the Ford Broncos or the Ford cars, and they were exploding. I don't know if you remember that. That was about 20 years ago. It was like, I'm only, probably some of you are like, I was 17. I don't know. But the bottom line is, they were thinking it was the manufacturer, and it wasn't. It turned out, it was a strict liability case, but they used the component manufacturer. I don't know if it was Goodyear or Firestone, and it was the treading in the tires that made the cars lose control. It was something about, and it was crazy, but the bottom line is everyone in the channel distribution, which would then led itself, let's just say it was Firestone Tires, along with everybody in the Ford chain was responsible, and people lost their lives. It was terrible. Does that make sense? And just so you know, there's gonna be a lot of lawsuits against Tesla, no doubt.
What do you mean there's going to be? What do you mean there's going to be?
Well, because if you watch the news, you guys should, people are falling asleep on the wheels with the system. You guys see that? And more importantly, the power steering is not working now. I mean, I was like, there's gonna be some problems, okay? Yes?
If the person falls asleep on while they're driving, isn't that consumer negligence instead?
It is, but it'll be very interesting that you have a car that allows you to do that. Do you see what I mean? But there's so much that goes into strict product liability, but the problem that they're gonna have is the steering wheel itself now, they're saying is very difficult to control,
Makes sense.
you know, so we'll see. But I'm just saying, you guys should just listen to the, you know, the news and try to find the accurate news, which is really hard to do today, but find out what's going on, honestly. You're gonna see that there's just so many lawsuits that are just being filed. Big lawsuit was always against the nicotine companies for cigarettes, because forever, I mean, you can watch TV Land to see it, but when you see like shows like I Dream of Jeannie, like Bewitched, the women, when they were pregnant, they were smoking cigarettes. You know, the old-fashioned movies, they had no idea back then that nicotine was harmful. They had no idea. People were just smoking cigarettes everywhere. You know, you see it all the time. Doesn't matter. Like they didn't know it was harmful. Well, big lawsuits were filed against all the big cigarette companies, and they lost because it turned out it was proven that nicotine is addictive. Plus, it can kill you. It can cause lung cancer and some various other problems. And so if you now know, if you look at cigarettes and any nicotine products, it says Surgeon General warning. That was added based off those strict liability lawsuits. Does that make sense? There's so much that you can see. That's why if you look at any drug product, I mean, I don't even know how you take a drug product anymore because you go, okay, this will help me because I won't have allergies, but I could pretty much die. You see what I'm saying? Like because it like has all the disclaimers. See that? But they have to do that now because it is such a high volatile strict product liability area. There's just so many different products that the reason why you see so many disclaimers, warnings, you have to. Does that make sense? You just gotta do it so you know what you're getting into so that people don't sue. That's the key. So it's interesting. But there's certain things that no matter if they put a disclaimer or not, if you have a brake that doesn't work in a car, does that make sense? Like, you can't get out of that. But like, if there was a product that, for example, you can use strict liability that. A lot of paint cases, I don't know if you know that, like certain paint cases, if you're in a closed area painting with the type of paint, whether it be latex or something, you could pass out or get hurt. Like if there's not there could be warnings, but if it's not conspicuous, if it's not big enough, does that make sense? Just so many things in life, you don't even think about it until you start learning the law. You're like, I know why it's like that. Does that make sense? There's reasons for it because products can be very harmful if you don't have the knowledge going into what it can do. Does that make sense? So take a look at that. What are the defenses to a strict product liability suit? Well, you've got the ones for negligence. Always couple these together, but there's something called commonly known dangers associated with a product. Okay, folks, there's just absolutely no way to write all the potential issues that someone can misuse a product, okay? So, for example, you buy a sharp knife, okay? And it's there to cut meat. You don't have to have a disclaimer on it saying this is to cut, not people. Do you see what I'm saying? Like it's common sense, but people are like, well, I stabbed myself, I'm gonna sue the knife company. You can't. Does that make sense? Commonly known dangers associated with the products. Please do not run with the scissors down the hall. Do you see what I'm getting at? There's so many things that people try to sue it, saying, well, there was no warning on this. Well, it doesn't matter. The proper, very valid defense is commonly known dangers associated with the product or misuse of the product. Does that make sense? And then there's federal, like government or federal regulations, which also are a proper defense. If the federal government preempted a product where they recognized its safety and then it turns out that they were wrong, it'll salvage the defendant's responsibility and the FDA picks it up. Does that make sense? It's like certain things where the FDA, they're the ones that have approved it and they can set up the risk when it comes to if they make a law that is conducive to getting someone hurt. It's really not the person's fault that put the product out, it would be the federal government. Does that make sense? Other than that, all the same defenses for negligence exist. Everyone clear? Because typically in a strict product liability case, you'll always have negligence as well as strict product liability together. Because if you can't prove that the defect existed, you could at least fall back and say that they were negligent. Does that make sense? That is why you evaluate them together. That's it in chapter 7. So we can jump into the homework. I'm just trying to go carry this along. Any questions? Okay, I'll leave leave it up to you. We have a substantial period of time. I can jump into the questions that Isaac didn't do. Or we could do a full review. What do you guys want? I can't hear, you can speak, people.
Do homework.
Full review.
Homework?
Do homework.
Okay, Eli wants to do homework. No one else is speaking, we'll do homework.
Full review.
Huh?
Full review.
All right, who wants to do the homework? We'll start with the homework. You know who those people are? I'm looking at them. Good job for doing the homework, Eli and John. And I'm telling the ones that did the homework, like, doggone it, do the homework. I spent time doing the homework. And what about the rest of you? You didn't do the homework, you wanted to do the
I did it, but just review sounds better.
Okay, all right, here's, I don't know why I asked. Okay, let's do this. I'm glad that you did the homework, but know that we will cover it extensively. It's just we're losing a day, and I feel like the best for your bet is now you know all of chapter 7, which wasn't a lot. But I want you to do problems 1 through 8. For those that already did 1 through 8 in chapter 6, feel good about it. Go back over what I'm gonna tell you if you don't know. Does that make sense? And then just come in on Tuesday. We're gonna attack 16 questions, full speed. And then that's the end of it. Tie a bow on it. We don't see you on Thursday, the 16th. I'll see you next Tuesday. You'll have 1 whole week, which is crazy because we do comprehensive reviews on each chapter. Does that make sense? And as you noticed from today, each lecture is typically 1 class period, and then we do other stuff. I start doing like the next unit, which is contracts. It's chapters 11 through 15. I do like a chapter and a half. Does that make sense? We kind of, we catch up to the syllabus is what we do. Does that make sense? It's a lot easier in learning. The first and most difficult part of this class is getting you to learn how to process in this way. And that's why I spend so much time on it. But then after, it's just regular speed. Does that make sense? So, all right, let's start. And if you have any questions, please ask. I'll take it super slow because we have time to do so. Chapter 2. What you really want to pull from chapter 2 is you're going to get fact patterns that really want to test you on, do you know if you're a plaintiff, do you have, is there even a valid reason why you're in court? And if so, are you following the proper civil procedure to ensure that A, you have a valid cause of action, and B, what jurisdiction are you following as far as state or federal, and are you using the proper channels to make sure that your case is properly going to be processed? And again, how do you get there? As a plaintiff, let's take everything slowly. Remember, a plaintiff is any legal entity that has the ability to actually sue for wrongful actions in the court of law. That could be an individual, that could be a group of people, it can be a partnership, a corporation, city, municipality, or even a governmental entity. Bottom line, these entities have the legal right to actually pursue a lawsuit as a plaintiff. Remember, likewise, these same legal entities have the ability to be sued, and that party that is sued based on a civil wrongful action being filed against them is referred to as a defendant. The first legal document, if you want to instigate a legal lawsuit against a defendant and you're the harmed party, the plaintiff, is called the complaint. Okay? The complaint is the first legal document that you as a plaintiff file in a court. In that complaint, the court has to have, when they look at that complaint, there has to be a couple foundational requirements that need to be satisfied. The first is that complaint has to somehow explain to the court that the plaintiff has standing to sue. Is there an actual valid reason why that plaintiff is in the particular lawsuit in the first place? Is that plaintiff in some way personally or directly, or is there a contract where you are impacted plaintiff directly? And if there was a threat, is it present? Is it imminent? Is it towards you? Whatever occurred, your harm had to be personal, and what you claim is you believe the defendant committed that harm directly to you. Harm comes in one of 3 forms. It can be financial, or it can be emotional, or it can be physical. But the bottom line is that harm has to be established in that complaint enough for the court to say there's a reason why the plaintiff is here, okay? Remember, you cannot base your particular complaint if you are harmed on something that's unright, which is called a hypothetical situation. If it didn't happen yet, there's no standing to sue. Also, if you believe morally that something is unfair and you believe for whatever reason you want to step in to protect that academic interest exclusively, that also is not going to pursue, you don't have standing to sue. Why? Because it's not personally affecting you. So remember, that is a very important issue, standing to sue. Once the court looks to see, okay, there's a reason why the plaintiff has been harmed, that's why they're here. But now let's see whether the court's here, right? We're looking at your complaint. The court now is saying, do I, as the court, have the power to speak the law, which is jurisdiction over that particular defendant? Is there a reason why I have the ability to decide this defendant's fate? Does that make sense? There has to be some sort of connectivity. I have jurisdiction over this defendant if the defendant resides within this territory or if the cause of action happened within the territory. I've established that the court, me, the court, has personal jurisdiction over the defendant. Let's say the plaintiff filed a lawsuit, they have standing to sue, but they filed it based on real property, and it's a dispute over real property against the defendant. They filed in the area where the real property is located. Again, if I'm the court, I can say I have property, or what we call in rem jurisdiction, over that defendant. So there's a connection there. I can proceed. Does that make sense? Or, let's say the plaintiff is suing a corporate defendant that has their principal place of business somewhere else, and or the cause of action happens somewhere else. It doesn't matter. If that corporate defendant places their products into the stream of commerce in any of the areas, including the area where the plaintiff filed the lawsuit, they've established sufficient minimum context to pursue the action there. They've established personal jurisdiction in this way. Got it? Now remember, if those areas are not there, and you're the court, and you say, well, the plaintiff has standing to sue, but guess what? There is no reason for us to make decisions over the defendant because there's no personal jurisdiction or property jurisdiction. So the plaintiff, the case would be dismissed, and the plaintiff would have to file this lawsuit either where the cause of action happened or the defendant resides. Does that make sense? But let's say that there is jurisdiction over the defendant and you're in that courtroom. Now the courtroom says, okay, I see here that the plaintiff has standing to sue. I see here that there's jurisdiction over the defendant, and they filed it in the right courtroom because we heard all general subject matters. Does that make sense? What if they're in that courtroom, they go, you know what? There's jurisdiction over the defendant, but we only hear probate cases. And this is a general subject matter. We gotta dismiss it. Do you see what I'm getting at? So you wanna make sure when you're filing that lawsuit, plaintiff, that not only that area has jurisdiction over the defendant, the court, but the court has to also have jurisdiction over what? The subject matter. Once you line all that up, plaintiff, you've got standing to sue. The court has jurisdiction over the defendant as well as the subject matter. You're in the right location, okay, as far as what you did. But now the defendant can take a look and say, whoa, wait a second. I get that I could be sued here, but this will not give me a right to a fair and speedy trial. So I'm going to oppose this location for trial based on venue. Does that make sense? They're gonna say, hey, I'm gonna bring to the court's attention the reasons why I believe I'll be prejudiced if I stand trial here. Maybe the publicity surrounding this case. Maybe there has been some leaks that are untrue. Whatever the situation is, if the defendant brings in these concerns to the court, even though the plaintiff has standing to sue, even though the court has jurisdiction over the defendant as well as subject matter, the case may be moved to a more probative, which is equitable location for that particular defendant to stand trial. And that is based on a venue concern. Does that make sense? And where is that plaintiff filing the lawsuit? Well, if the plaintiff were to file it in the state court system, it's because the subject matter that they filed the lawsuit in, the lawsuit is either one of U.S. constitutional issue or pretty much everything except a federal question. Does that make sense? The only exclusive jurisdiction here is federal questions are reserved for the federal court system. However, you can have concurrent jurisdiction if you're filing a lawsuit plaintiff based on a US constitutional violations. Both areas can listen to the case. Everyone clear? So if you're in the state court, the plaintiff files it, it's either because it can be anything and everything except a federal question. It's really what it comes down to. Everyone clear? So if you are here in state court, the first court that has original jurisdiction over your lawsuit is called the state trial court, okay? These courts are plentiful, and they are gonna make a decision. Once they do, it's tapped, your case, whatever it is. Joe versus Sally has, this Long Beach Superior Court has original jurisdiction over your matter. If either plaintiff or defendant is not happy with the result, they can, I don't know if it's gonna be successful, they have the right to pursue an appeal. Whether it'll be granted depends on what the appeal is about. What is an appeal? It's a reviewing process. If you make an appeal, it would go to the state appellate courts, okay? And there's about 3 or 4 judges in this situation. The appeal is brought up to them, they take a look at it, and typically, if your appeal, whether you're the plaintiff or defendant, is based on a proper question of law, it will be granted. Because what you're basically suggesting to the appellate court is, there's something that happened in the trial court that was out of our control, but the legal system mismanaged or did some sort of negligence, which could have probably or potentially caused that, change the outcome of the case. If that occurs, your appeal is granted. If not, people are human, they make mistakes. You have another shot to base the same appeal and go toward the state Supreme Court. There's one in every state located of the state. However, a lot of times people are fueled by emotions and they base their appeal on what we call questions of fact. Who is a fact finder? The juror. If that juror is taking a look at deciding a case, it really is based on their opinion, based on the evidence presented and the credibility. So if you are unhappy with the way the jurors evaluated the case and you base your particular appeal on a question of fact, it typically is denied unless no reasonable jury would have come up with that decision based on the evidence presented. So take a look to see, and it goes through the same channels. Make sense? Okay, now the same type of assessment for appeals is equally true for a federal court system. But if you're in a federal court, it's because you have to be, because you're filing a federal question, or maybe it has concurrent jurisdiction and you're there because it's a US constitutional violation. But if you want to take your everyday action into a federal court, again, you have to get in because it has to satisfy some sort of federal subject matter jurisdiction. How can it do so? Well, if you satisfy what's called diversity of citizenship requirements, where the plaintiff and defendant are citizens of 2 different states and the aggregate amount that the plaintiff is suing for must be at least $75,000 or more. If that's the case, you can take your particular action and file it in the federal trial courts, which are referred to as the U.S. district courts. With that in mind, the same thing happens for the appellate process, but it would go to the U.S. Circuit Court of Appeals, there are 13 being District of Columbia, and they evaluate your case. Again, the U.S. Supreme Court, our judicial branch, is the national premier law-making body of the country. It precedes the state and the federal courts. And you can get there traditionally, the traditional way, keep going through, but no matter what, you have to submit a writ of certiorari. And that is taking the transcript from the state or federal court system and completing it and writing a writ to the U.S. Supreme Court. If the U.S. Supreme Court, out of the 9 Supreme Court justices, 4 ratify that writ, you have your day before the United States Supreme Court. But you don't have to go through the actual traditional process. You can do it from home or just wherever you want. The bottom line is the primary function of the United States Supreme Court is an appellate body, but it also is a Supreme Court, which means it is also a court of what we call original jurisdiction if it chooses to do so. But typically, the writ of cert has to be provided for them to make that review and assessment. But that whole process costs a lot of money. If you want to stay out of court, you should use what we call alternative dispute resolution methods. And the 3 that you're going to be tested on, and the most common sense one to avoid lots of money is just negotiation. The more you're good, and I say this for business students, I don't care if you're going to be a lawyer, take a good class after as you proceed with your education. Even if you're done after this, still take a class, a strong class in negotiation. It is such an effective tool in business as something that you should have as far as resources. But negotiation is just being able to talk to the other side with confidence to try to resolve the case. And it can be done without a lawyer. And people that are very good at negotiating don't really need a lawyer, and somehow they seem to get what they want. Does that make sense? However, if you can't resolve the case without the assistance of a lawyer, your advocate, which is your lawyer, will be your spokesperson. They will advocate on your behalf. But negotiation can be done before a lawsuit's filed, during the lawsuit proceeding, even after. Bottom line, it's an ability to try to resolve and settle the matter in your favor with the other side. Next up is something called mediation. This can be done before a lawsuit's filed or even when the lawsuit's filed. It is a neutral third party called a mediator that takes a look at the potential conflict, or if it's in litigation, the lawsuit itself, and tries to resolve it by looking at the strengths and weaknesses of both sides. And if it's binding from the start, whatever the mediator says, if it's before a lawsuit's filed, no lawsuit will be filed, because whatever the mediator says, both sides decided on. If a lawsuit's filed and you want a binding mediation, you forego your trial, whatever the mediator says goes. If not, it's still very valuable to show the value of the case. Then we have what we call arbitration. There's a couple different variations. If a contract says all disputes must go to arbitration, just go, okay? Try to get it resolved there. And the bottom line is, if it's one-sided or you think it's somehow oppressive to you, you can file your day in law. You can have your day in court and file a lawsuit. But once you're in litigation, the court itself may suggest that that particular case be set for arbitration. Here, again, you can make it binding or not binding. If it's binding, the arbitrator is a neutral third party, typically a retired judge. They listen to the value of the case, and they put whatever they believe on it. If the defendant wins, they'll say how much. If you decide that it's not binding, and it goes to trial, and you lose, as the plaintiff, you have to pay the defendant's costs. That makes sense? But typically, whatever they say really does try to get you to settle before you waste court time and trial. And that's a really effective tool. Okay, that's chapter 2. When you look at chapter 3, we look at our intentional torts. Here we go. What is an assault? Take a look. An assault is intentional conduct by the defendant which creates in the plaintiff awareness of an immediate harmful or offensive contact. What is a battery? Intentional conduct by the defendant which has to create harmful or offensive contact. Both torts are excused if the plaintiff gives consent to an activity that may be viewed as harmful or offensive. Both torts are excused if you as a plaintiff are using reasonably necessary force to protect your property. Both torts are excused if you had to use deadly force because the defendant provoked you with deadly force and you were protecting your life or the life of another. If you have the tort of false imprisonment, it exists where the defendant intentionally uses, confines, restricts, prevents, or prohibits the plaintiff from exercising the plaintiff's own free will and there are no reasonable means of escape. This also extends to constructive false imprisonment, which is tools that the plaintiffs bring that the defendant prevents the plaintiff from holding on to, which their property they're entitled to, okay? The bottom line is, this is very actionable if it's simply the elements exist. However, it's also a tool that's used to give immunity to traditionally what is referred to as the shopkeeper, today referred to as the merchant. A merchant is anybody who ordinarily engages in buying and selling of goods, and that's what they do for a living. And here, in order to protect their stuff from getting ripped off and stolen, what we have implemented is the immunity blanket of shopkeeper's privilege. If the traditional shopkeeper exercises shopkeeper's privilege effectively, and it turns out that the person they believed did not take product from them, that person cannot sue them for the tort of false imprisonment. It's exercised effectively if the shopkeeper or their agent has reasonable suspicion that someone's stealing product from their store, they detain them in a reasonable manner and only for a reasonable period of time. If that's true, they actually have an immunity or a blanket of immunity from that particular tort. We have the tort of intentional infliction of emotional distress. Here, the defendant's conduct intentionally has to be extreme and outrageous. This extreme and outrageous conduct has to approximately cause the plaintiff to suffer some severe emotional distress as well as cause some sort of physical manifestation of their symptomology. Think about the type of extreme conduct that's involved in order for it to be actionable. If you see the tort of defamation, here, there's 2 forms. Libel is the more permanent form. Slander is the verbal form. The per se category is that the defendant makes a state false statement, loads and disease about the plaintiff, that the plaintiff did time for serious crime or felony. Or the plaintiff did some sort of impropriety regarding a profession or trade, and it's based on where the defendant intentionally makes a false statement of a material fact and publicizes it about the plaintiff, causing approximately the plaintiff to suffer damage to the plaintiff's reputation, where there is no truth to the statement or absolute or qualified privilege. Truth is a complete defense to the tort. Remember, absolute privilege covers immunity for judicial or legislative proceedings and statements made therein, and qualified privilege is applied to when you're obtaining from good faith, reliable resources, something about the person that turns out to be false, you're protected from the tort. If you are a public figure suing for the tort, you have to prove the elements I just stated, but you have to show that it was done out of malice, otherwise it's no more than 50% statement. If you are trying to establish the tort of invasion of privacy, 4 separate subtorts. The first is appropriation. You have to show if the defendant intentionally appropriates, which is wrongfully takes, withholds, or uses the plaintiff's name, likeness, image, or identity without the plaintiff's permission for the defendant's own economic benefit. This tort is actionable. Next up, we have intrusion. If the defendant intentionally intrudes into the plaintiff's private affairs or seclusion, this tort is actionable. Then we have false flag. If the defendant intentionally places the plaintiff in a position that the plaintiff normally doesn't hold, we have the tort of false flag, using typically opinions, suggestions, inferences. Then we have the tort of invasion of privacy through public disclosure of private facts. Here, the defendant will intentionally disclose truthful private facts about a plaintiff, but they do it in a way, in a venue that they shouldn't. This is actionable as an invasion of privacy tort. Then we have the tort of fraud. We kind of covered that, intentional misrepresentation, but let's cover the other one, deceit or concealment. Here, the defendant intentionally withholds material information from the plaintiff. The plaintiff relies to their detriment because they're unaware of that material information and approximately causes the plaintiff harm. Then we also have the tort of abusive prosecution, or what's called malicious prosecution or abusive litigation. It's when the defendant intentionally files a lawsuit against the plaintiff knowing doggone well there's no cause of action. It's easy to prove, and if so, it is actionable as an intentional tort. Then we have our business torts. Wrongful interference with a contractual relationship exists where the defendant is aware that the plaintiff and a third party are in a contract, and then the defendant intentionally causes that contract to terminate. Then we have another business tort. Here, the defendant is using predatory methods or targeting or soliciting an established business relationship. It's just called wrongful interference with a business relationship. They just have, there's some sort of prospective business relationship even, but if that defendant intentionally is a creditor, targets or solicits a prospective business relationship or an existing one, this tort is actionable. Remember, purely competitive methods are not actionable. Then we also have the torts of trespass to land. Here, it's intentionally when a defendant enters onto the plaintiff's property without the plaintiff's permission, it is actionable. But remember, it's justified if you're entering onto someone else's property for some sort of exigent or emergency situation. Then we have trespass to personal property as well as conversion. Both torts have the same elements where the defendant intentionally and wrongfully interferes with the use and enjoyment of the plaintiff's personal property. It's actionable, both torts are, but remember, conversion is one where the particular damage is just more irreparable or more severe. Then we have disparagement of property. It's defamation of property, it's just called disparagement of property. The permanent form is called trade libel, the verbal form is called slander of quality. Then let's flip it over to negligence. 4 areas, 4 elements for one big tort. 4 elements. The first is duty of care. You have to show, first of all, did the defendant owe a duty of care to that plaintiff? If so, typically they're going to be assessed under the reasonable third-party standard. If it is someone that has a relationship that is professional with a particular plaintiff, that particular person will be assessed as similarly situated professionals in that area and seeing what they do to determine that duty of care. Ask yourself after, if there was a duty of care between that defendant and the plaintiff, was a breach? If so, was that breach of that specific duty of care the foreseeable cause to the type of harm the plaintiff suffered? If so, negligence has been established. If so, the defendant can say, well, maybe there were some defenses that applied. Was there some sort of assumption of risk? Did the plaintiff knowingly, willingly, and voluntarily, knowing the risk, still took it, causing him harm? Guess what? There goes the case. The defendant would not have to pay a dime. Also, maybe the defendant can show that the plaintiff was contributory negligent. maybe the plaintiff in some way contributed to their overall harm. If they can prove this, the plaintiff gets nothing. Remember, this is a comparative negligence jurisdiction. It is, if there's pure comparative, it's true apportionment of fault, but if it's a modified comparative, more than 50% you prove, they have to pay. So take a look. And then we have what the big overall category, superseding forces. Here, these are what we call events that break the chain of causation between foreseeable causation and the type of harm the plaintiff suffered. Typically, acts of God, things of nature, things that you cannot control contribute to this situation. Then we have our special negligence doctrines, which are negligence per se. Here, if the defendant intentionally breaks some sort of law that could be sanctionable under criminal conduct and approximately causes the plaintiff harm, this is actionable under negligence per se. Good Samaritan statutes provide immunity to medical registered personnel of any sort. If they come to aid to someone in danger, they will have a blanket of immunity from the tort of negligence. Then Dram Shop Acts provide culpability to anybody selling any type of alcohol to someone who's visibly intoxicated. If they do so, they can be pulled in and hailed as co-defendants in the lawsuit. Then we have, real quickly, strict liability, abnormally dangerous activities. Here, these are activities where the risk of harm is so severe that even to try to remove the harm, the risk still is there. This criteria is why, if you are a defendant engaged in one of these types of activities, you will be strictly liable. Wild animals, again, please know that generally wild animals or farm animals and exotic creatures, they, without provocation, cause harm to someone, you're gonna be strictly liable for that resulting harm. And then we have strict product liability. Remember here, if the defendant releases a defect into the stream of commerce and that particular product does not undergo any substantial change not caused by itself and approximately causes the plaintiff harm, any plaintiff that is harmed by that defect is a proper plaintiff to sue. The defendant would be anyone in the channel of distribution is a proper defendant, and the additional types of defenses are product misuse or commonly known dangers associated with the product, as well as federal preemption. Do your homework. I will see you guys on Tuesday.
Yeah, four.
I had a
Today, we do not have classes. On Thursday, it's a flex administrative day, so you guys don't have classes, so you have 1 week to technically polish instead of cram, but, the chapters inclusive, very comprehensive in chapters 2, 6, and 7, and the vocabulary that I've already integrated from chapter 3 will be, the words when you shouldn't have the words, okay? So let's pull out our homework. We're gonna do something a little different because I wanna make sure I get through all the chapters. I'm gonna go handle the questions myself and process them. So then I will give you, if you have questions after each question, let me know instead of having you collaborate with me this time around, just so we have more time for any questions that you may have. All right, let's take a look. All right, let's take a look. What I want you to do, please know this, the homework questions that we've gone over are meant to comprehensively test you on each area of law that's covered in the chapter. But understand that the fact patterns are much simpler. They're much more effective as far as what the answer should be. There's only one best choice. You need to know that you have to pick the best. There could be something that's correct, but it's not the best correct choice. Everyone clear? So you really have to comprehensively know your stuff. When we go through the homework questions, it's meant for you to just think about
all the different components. Everyone clear? You're not gonna have open-ended questions on a multiple choice test. Everyone clear? And again, it's 50 questions, 2 points apiece, and that's gonna each question, but there's gonna be, I don't know how many, really don't know if there's 15 or 20, I think 15 true false and the rest are multiple choice. But it is timed, please know this, I'll just tell you all the instructions up front, because you guys get lost in the confusion or stress, I guess, on test day. The students that have already gotten everything done for DSPS testing, the test will be provided for you at that time. So take it within the same time frame. I mean, go over there when you're supposed to have class, and they will handle the exam rules there and the guidelines for you. For the rest of you, when you're in class, make sure that you don't waste time. Be prepared. Have your Scantron, have your pencil. I know it seems like a stupid little thing, but you are not to ask a neighbor once the test begins for anything, because it's called cheating and you get a 0. Everyone clear? I don't care. I have so many students, do you have a Scantron? Are you kidding me? Do not mess up their zone. Does that make sense? Because students are, you guys are really nice, and you get irritated, but you'll help your friend, or, but you don't, it's kind of like, dude, I need that 1 minute. You know what I'm saying? So please don't do that. If you do, I'm gonna say, don't do that. I'm gonna instruct the student who wants to help you, not to help you, and you have to go down and get your materials. You see at the Express, there's a little store down here. Everyone clear? So come prepared, have a Scantron, and again, some more rules. Make sure it's not wrinkled. The whole purpose of a Scantron is that you can get your test back very quickly. I already have classes where I have to grade lots of writing. Okay, the reason I'm happy with 18, well, 18, I just put it through. Everyone clear? You have a wrinkly Scantron, it may be the last test that I look at, and because I have to do it by hand, and you may not even get it till later. Does that make sense? So, and please use a number 2 pencil. I've had students use pen. You get a 0. I do not give you time to, that's just dumb. Everyone clear? I can't help that. You're gonna learn a valuable lesson. Follow directions. Also, know that I will tell you when there's 30 minutes, 15, I give you then 5 and a 2-minute wrap up. If you have open spaces and a multiple choice true and false test and have a 2-minute wrap up, I don't understand this because I'll be looking at students where I know they haven't completed the exam, and they sit there and try to figure out that one last question. But when I see pencils down, if your pencil is up, you get all the rest wrong. Whatever you're marking, it's wrong, and everything else should be done. Does that make sense? This is ridiculous, and people think that it's mean that I test this way. I'm like, what? You're supposed to know this within a time frame. Typically, it's 35 minutes. Everyone clear? You get 60. Everyone clear? Please know the test is to be completed in 35 minutes, but do the math. You get 60. I don't care what it is. But when I see pencils down, all pencils are down. Everyone clear? Please know that is how I run exams, and you will be appreciative of this rule as you grow with your academic growth. Everyone clear? Because not every, I do not understand teachers that just go, oh, take your time, everyone else has a certain time, but then someone walks in late, that's ridiculous. Everyone clear? You got a time and a stop, it's a start time and a drop time. And the people that have more time, for whatever reason, it's for equitable purposes, it's a DSPS. So there's no disadvantage or advantage. Everyone's got the same stuff. Everyone clear? And know that I'm very firm with those rules, period. There's no exceptions. So if you walk in late, you can take the test, but you only have, 20 minutes to take it. Everyone clear? Whatever the time is. You miss taking the exam, well then it's a 0, and that's the test I hope you drop, and you don't miss any other exams. I do drop your lowest score. It's for any unforeseen circumstances, and that's what it should be used for. The only time, remember, that I do give makeups is for an exigent, tragic situation that was completely unavoidable. Everyone clear? But you need to make sure you communicate those situations with me directly. Okay, got all that out, but read your syllabus too. Everyone clear as far as grading? And know that I post all your grades in Canvas. Those are the only things that are in Canvas, the syllabus and your grades. Got it? Because it's a face-to-face instructive class. Everything else is face-to-face. But your grades, so you can take a look at them. Don't ask me what they are. They're going to be in Canvas. But please know I have an open window of going over the exams. You should come see your exam during office hours. That is available to you, but that window is only available for that
like following 2 sessions, and then it's closed, because I'm gonna help you with the new material. That's how it works the entire semester. But I do recommend that you go over your exam, no matter how well or how poorly you perform, so you don't make the same mistakes and you know the areas that you should actually study some more, because the final is comprehensive. Got it? Okay. All right, let's look at number 1. It reads, Richard is an employee of the Dunn Construction Corp. While delivering materials to a construction site, he carelessly backs Dunn's truck into a passenger vehicle driven by Green. This is Richard's second accident in 6 months. When the company owner Dunn learns of this latest accident, a heated discussion ensues and Dunn fires Richard. Dunn is so angry that he immediately writes a letter to the union of which Richard is a member and to all other construction companies in the community, stating that Richard is the, quote, worst driver in the city, unquote, and that, quote, anyone who hires him is asking for legal liability, unquote. Richard files a suit against Dunn, alleging libel on the basis of the statements made in the letters. Discuss the result. Now, this is a big fact pattern, but let's break it down. First of all, you have to know what the question's asking. What is libel? Remember, libel is the permanent form of defamation, right? So it's when you do not have to recreate the potentially libelous statement. It's there to read over and over again, hear over and over again, see over and over again. The bottom line is it's not something that needs to be recreated as far as said. It's not verbal. Everyone clear? So we know, let's look at the elements for the tort of libel. Remember, it's the permanent form of defamation. So it says, alleging libel on the basis of the statements made in letters. So in order to understand this, you need to know the elements of each tort. You gotta always put that in your head as you're attacking each question. Everyone clear? So what is libel? Remember, it's an intentional tort. It's when the defendant intentionally makes a false statement of a material fact about the plaintiff that's published. What is publication? It means that at least a third party can hear it or read it. The bottom line, it needs to be communicated at least to a third party, and that publication must cause that plaintiff, approximately cause the plaintiff, to suffer damage to the plaintiff's reputation where there is no truth to the statement or absolute or qualified privilege. And again, since there's no indication here that these are public figures, you don't need to show it has to be done out of malice. Everyone clear? Okay, so let's break it down here. It says, Richard files a suit against Dunn alleging libel, on the basis of statements made and discuss results. So if you're the plaintiff here, Richard's the plaintiff, and you're suing for the tort of libel, remember, the first thing you want to prove is this a false statement of a material fact made about me? True? That's what you gotta, about the plaintiff. And so let's take a look at the statement. It says, Richard's member, okay, so he says he's basically, this is Richard Sexton. Okay, Dunn learns of the, all right, here goes. It says, the letter states, Richard is, quote, the worst driver in the city. Okay, think about if you think this is a factual statement about someone. Everyone clear? This is the worst, you're the worst driver in the city, and that anyone who hires him is asking for legal liability. Now, this would be, if you're a plaintiff, and I'm gonna play plaintiff and defendant, everyone clear? If you're the plaintiff, which Richard is, you're gonna really push this issue, because you don't have any case for defamation unless you can show that this is a factual statement, not an opinion-based statement. Everyone clear? And so, do you have this element? I don't know, you're not gonna have to guess on a test. This is trying to elicit thought, so you know it has to be a factual statement about him. I would claim, if I was the plaintiff, that this is a factual statement because there's no reason for you to send material like this to other construction companies that I'm not working for, other than to prove something, you know, that you believe is untrue. I'm not the worst driver in the city. Does that make sense? And people that hire me are not asking for legal liability. It was published because it was sent to other members of the union of which Richard's a member of. They weren't requesting it to be this previous employer sent it. So the publication element's met. Does that make sense? Now, what isn't met, which it doesn't say here, is economic damages. Does that make sense? I don't know. Is he unhirable after? Does that make sense? That is a question you need
need to know. If you're gonna win and be successful for the tort of defamation, if you gotta prove that false statement of fact, you need a publication element, but you also need to know that it caused you some economic harm. Does that make sense? We don't know if he couldn't get a job for the same type of position somewhere else. Everyone clear? So that needed to be proved in order for him to be successful. Let's flip that quarter though. If I were the defendant here, I'd try to really poke holes in the fact that I believe this is an opinion statement. Everyone clear? Not a factual one. Do you see what I'm getting at? You just have to kind of evaluate that. You say this is an opinion statement. It's not a factual one. You do have the publication element, but the bottom line is you don't have the economic harm. But let's say that Richard were to prove that he couldn't get a job in the same business. You may claim truth. Oh, hey, I hired him, second accident in 6 months. Do you see what I'm saying? You're gonna work it. Saying truth is a complete defense, you can work that. And the bottom line, you're not gonna be able to use absolute privilege. Absolute privilege is used for judicial or legislative hearings, so if that doesn't work. You may try to use qualified privilege, but that would also fail because these people are not requesting information on Richard, you're providing it. Everyone clear? What I've done is gone through all the elements. Does this make sense? And that's what you need to do in order to direct your attention on the test. Go through the elements and answer the question. Everyone clear? Yes or no? Okay, any questions with this first one? Okay, let's take a look at number 2. It reads, Kim went to Ling's Market to pick up a few items for dinner. It was a stormy day and the wind had blown water through the market store each time it opened. As Kim entered through the door, she slipped and fell in the rainwater that accumulated on the floor. The manager knew of the weather conditions but had not posted any sign to warn customers of the water hazard. Kim injured her back as a result of the fall and sued Ling's for damages. Can Ling's be held liable for negligence? Okay, I think I kind of discussed this, but I'm not sure, so let's get into it. We have they're talking about the tort of negligence, right? Remember, for negligence, you have to establish 4 key elements. Number 1, you have to show that there was some sort of duty of care owed between the defendant and the plaintiff, which would be Ling's Market and Kim. Ling's Market's the defendant, Kim is the plaintiff. You have to establish, was there a duty owed? And if so, in your head, you gotta say, what was that duty, right? If there was it breached? Did the defendant breach their duty to the plaintiff? And if so, was that breach the foreseeable cause to the type of harm that Kim, the plaintiff, suffered? Everyone clear? So tie it up. We know that, you should know this, if you are open to the public for any type of potential or prospective economic advantage, you have an additional responsibility of duty to those people. It's a higher duty of care. It's not the reasonable third-party standard. It would be one that is, again, because you potentially can make money off of the sale, you have to make aware to people coming to your business of any known or unknown dangerous conditions. You have to make a reasonable inspection of any known as well as unknown dangerous condition and warn customers. That's why if you go to a grocery store, if you see the cones that are food spilled, they have a responsibility to warn customers in the store that there could be a fall. That's why they put a cone there. They want to avoid that responsibility if you get hurt by giving you warnings. If they have that, like basically extra duty to check their premises to make sure that there are no dangerous conditions that they know about or even that they may not know about, okay? So here, let's take a look. Did Ling's owe a duty of care to Kim? Well, they definitely owe a duty of care. They're open for to the public, and she's going to the grocery store, so you have kind of that higher duty to warn potential prospective customers of known as well as unknown dangers. And the facts reveal, I'm reading right from the facts, it says the manager knew of the weather conditions but had not posted any sign to warn customers of the water hazard. So you had knowledge of this. Does that make sense? So you had a duty of care here to warn him that there was water in the entranceway. Everyone clear? Did you breach that duty of care? Did you do it? Did you warn her? No. Is it foreseeable that if you didn't know not know that there was water in the entranceway, you could slip and fall. Is that what happened? Yeah, it led to the type of harm the plaintiff suffered. So can you establish negligence against the market, yes or no? Okay, any questions? Okay, let's take a look through. All right, it reads, Sharon Eagle was an assistant to the Vice President of Student Affairs at Virginia Polytechnic Institute and State University, Virginia Tech. As part of her duties, Eagle helped students participate in the Governor's Fellows Program. The Collegiate Times Virginia Tech student newspaper published an article about the university's success in placing students in the program. The article's text surrounded a block quotation attributed to Eagle with the phrase, quote, director of bootlicking under her name. Eagle sued the Collegiate Times for defamation. She argued that the phrase implied the commission of sodomy and was therefore actionable. What is Collegiate Times' defense to this claim? This is actually quite ridiculous, but let's take a look. Obviously, what you want to work on, if you're a defendant, again, defamation, what is the tort? Okay, how do you establish it? Intentionally, a false statement of material fact, right? Published about the plaintiff, approximately leading that plaintiff to suffer damage to the plaintiff's reputation, where there's no truth or absolute or qualified privilege. So if I was a defense attorney, I would definitely say this is an opinion statement. It's absolutely ridiculous that you could think that it means sodomy. That just means you're kissing someone's ass. This is kind of part of the American lingo. It is not a material statement of fact, it is an opinion. Everyone clear? You definitely, you'd be very successful at that, because most people reading it does not, their mind doesn't go to sodomy. Everyone clear? That's cray-cray, and if your mind does, you've got issues. So, bottom line, you're not gonna be able to establish a material fact, but let's say you do, okay? But she didn't lose her job. Everyone clear? Like, you're not gonna be, your defense is, whatever you wanna publish, you could say, there's no, factual statement here made, it is an opinion, so you don't have that first element. Even if you have publication, she's still whatever, the assistant to the vice president, and basically, they talked about the success in placing students. Does that make sense? Which means she didn't lose her job, you don't have damages. You may wanna try to explain truth because she is trying to do a good job, everyone clear? But you will not be able to provide the elements necessary to establish the tort of defamation. Any questions? Let's take a look at the board. All right. While living in her home country of Tanzania, Sophia K. signed an employment contract with Annie B., a Tanzanian living in Washington, D.C. Kay traveled to the United States to work as a babysitter maid in B's house. When Kay arrived, B confiscated her passport, held her in isolation, and forced her to work long hours under the threat of having her deported. Kay worked 7 days a week without breaks and was subjected to regular verbal and psychological abuse by B. Kay filed a complaint against B for intentional infliction of emotional distress, among other claims. B argued that Kay's complaint should be dismissed because the allegations were insufficient to show keywords here, outrageous intentional conduct that resulted in severe emotional distress. If you were the judge, in whose favor would you rule and why? Again, this is an opinion statement for you to know the elements of the tort of intentional infliction of emotional distress, so let's get into it. In order for this tort to be actionable, you have to show that the defendant's conduct intentionally was extreme. It was outrageous. It was very unreasonable, and it goes above unreasonable. It's extreme, outrageous, crazy conduct, and this conduct by the defendant proximately caused this particular plaintiff to suffer severe emotional distress. But remember, in the state of California, not in DC, but the state of California, you gotta know California law here, is you have to show some sort of physical manifestation of your symptomology. Make sense? Now, the question here is, if you were a judge, in whose favor would you rule and why? Well, in the state of California, if you were the judge, I think the conduct does rise to extreme and outrageous. Does that make sense? Because you're basically forcing someone to be a slave for you. Everyone got that? And it's a form of also false imprisonment, if you know that. But that's not what the question reveals. But I would say that this type of conduct is outrageous. It does circumvent labor law. You're supposed to not do that. Okay, you can't. So it is extreme, it is outrageous. Now, it says, she filed a complaint against B for, and then it says B argued that should be dismissed. So K filed this complaint. She says she has psychological abuse. Well, she has to show in her complaint that she had severe emotional distress, but in order to recover as a judge, she would have to show that she also suffered what? Some sort of physical manifestation of the severe emotional distress to be successful. Does that make sense? Any questions? All right, let's look at, no questions. Okay, it reads, at the Weatherford Hotel in Flagstaff, Arizona, room 59, a balcony extends across 30 inches of the room's only window, leaving a 12-inch gap with a 3-story drop to the concrete below. A sign prohibits smoking in the room, but invites guests to, quote, step out onto the balcony to smoke. Tony Lucario was a guest in room 59 when she climbed out of the window and fell to her death. Patrick McMurray, her state's personal representative, filed a suit against the Weatherford. Did the hotel breach a duty of care to Lucario? What might Weatherford assert in its defense explain? Once again, talking about negligence, you're open to the public, you have an extra duty of care to warn of dangers that are known and unknown. So here, you have to establish, if you are the plaintiff, if you're the decedent's estate on her behalf, you have to show that there was a duty of care owed between the hotel and Tony Lucario. Here, you could absolutely say your duty was breached because you told them to go outside. You can't smoke in the room, but it invites guests to step out into the balcony to smoke. And it says, you know, it's kind of strange. It says she went out to the balcony when she climbed out of the window and fell to her death. It says there was a gap with the it's a 12-inch gap. She's awfully skinny, isn't she? I don't know. It says a balcony extends across 30 inches of the room's only window, leaving a 12-inch gap with a 3-story drop to the concrete below. The bottom line, you would have to say the fact that the hotel is inviting you to go out to the balcony to smoke, and there is a possibility you could fall to your death based on the way it is. Doesn't show that there's any guardrails. Does that make sense? Let's say it was a huge balcony. Everyone clear? But there's no guardrails. That's still dangerous. Everyone clear? So whatever the deal is, when you don't have anything other than 30 inches of the room leaving a 12-inch gap, it doesn't say anything about guardrails. I would definitely say due to this, they had a duty to make sure that people are protected if they're going to go out to the balcony and smoke. Does that make sense? That duty was breached. Is it foreseeable if there's no protections to the only place that you can smoke when the hotel invites you to go there? If there's no guardrails up, that is foreseeable that you could fall? Sure. And that's what happens. You can establish negligence, but it said, what might the Weatherford assert in its defense? Explain. Well, let's go through it. You could say assumption of risk. Everyone clear? Even if you have a son that says, go out here and smoke, how stupid are you to go out there and smoke if there's a possibility? It's like, go out on this ledge and smoke. Does that make sense? That you actually go. You saw the risk. You still took it, despite knowing you could fall. Does that make sense? You probably would use that as one of your defenses, contributory negligence. What is that defense? If the defendant, if the plaintiff in any way contributed to their overall harm, they get nothing. Does that make sense? So these are some things that you would be evaluating in order to defend against any form of liability. Any questions? It's not so hard. You just kind of work through the elements, okay? Let's take a look at 6. Any questions with 5? Any questions with 1, 2, 3, 4, 5? It reads, Ronald Rouse and Xavier Bailey were in an auto accident in Bridgeport, Connecticut. Bailey rear-ended Rouse at a stoplight. Evidence showed it was more likely than not that Bailey failed to apply his brakes in time to avoid the collision, failed to turn his vehicle to avoid the collision, failed to keep his vehicle under control, and was inattentive to his surroundings. Rawls filed a suit in Connecticut State Court against his insurance company, Progressive Northern Insurance, to obtain benefits under an underinsured motorist clause, alleging that Bailey had been negligent. Could Rawls collect discuss? All right, this is not a defense, I'm not gonna touch you at all on last clear chance. That's what they're really referring to here. The reason why, it's a little too, over the scope of foundational learning to make that kind of a guesstimate, but, it says evidence showed that it was more likely than not that Bailey failed to apply his racing time. And there's a defense that you're not gonna get tested on, it's called the last clear chance. If you, as a defendant, had the last clear chance, if you had the last clear chance to avoid getting into the whatever incident or accident and you didn't take it, you could be held liable, okay? I don't like that defense because it's incomplete in the context of learning. Everyone clear? Please know that, just moving on, one less thing to study, but, it's put in here just, I wanna give you a heads up, I don't want you to think you have incomplete learning. I'm trying to make sure you have comprehensive foundational learning. Everyone clear? So know that, those are interesting facts, but I don't want to belabor a point that you won't really have to be tested on. But be aware, there's so many different defenses that come into play, and I'm actually just making sure you know foundational defenses. Any questions? Let's take a look at 7. It reads, Charles Robinson, an employee of West Star Transportation, was ordered to cover an unevenly loaded flatbed trailer with 150-pound Charles Flynn of waterproof cloth. The load included uncrated equipment and pallet crates of different heights, about 13 feet up and down at its highest point. While standing on the load, manipulating the tarpaulin without safety equipment or assistance, Robinson fell and sustained a traumatic head injury. He filed a suit against Westar to recover for his injury. Was Westar negligent in failing to provide a reasonably safe place to work, as Robinson's claim explained? Okay, these are, again, very open-ended facts that want to have a discussion so you know the elements of negligence, okay? Now here, in order to establish duty of care, if you're an employee, you have an employer, you gotta make sure whatever the employee is aware of the danger, right? We don't know the bottom line, but we don't know if this is a 1-person or 2-person job, everyone clear? Or what kind of safety equipment says here, without safety equipment or assistance. Looking at it, it looks like it should have safety equipment. The bottom line, you could say there's a duty at least to provide safety equipment to do this, because that's a lot of, if you're ordered to cover an unevenly loaded flatbed trailer, if you just picture all the stuff on a trailer, that could come on you and hurt you, does that make sense? And there's no protection for you as a worker, you could make an argument that they did have a duty of care to at least provide some sort of assistance or safety guidelines at least, and that wasn't there. Is it possible that in this situation, if you're trying to cover this, 150-pound, not 150 pounds, the blanket or the cover was 150 pounds, was trying to do this by yourself on uneven material, crates, could you fall? Sure. Does that make sense? It's just like, could you prove negligence? You could with the facts as stated here. I don't know anymore, but these are things that you need to consider. Were there warnings? Was there equipment? Was this a situation that was a 1 or 2 man or 3-person job? Does that make sense? I don't know. But these are things that, when you see fact patterns, that I want to have float in your head to say, was there negligence? Once you establish the duty, was it breached? And if so, just connect it. Everyone clear? Any questions? All right, lastly, let's take a look at chapter 6, number 8. It reads, DST, Industrial Supply and Road Rider Supply, and Supply are located in North Kitsap Business Park in Seattle, Washington. Both firms are owned by Paul and Suzanne Marshall. The Marshalls have outstanding commercial loans from Frontier Bank. The bank dispatched one of its employees, Suzanne Gould, to North Kitsap to spread Christmas cheer to the marshals as an expression of appreciation for their business. Approaching the entry to Road Rider, Gould tripped over a concrete wheel stop and fell, suffering a broken arm and a dislocated elbow. The stop was not clearly visible, it had not been painted a contrasting color, and it was not marked with a sign. Gould had not been aware of the stop before she tripped over it. Is North Kitsap liable to Gould for negligence? Explain. Okay, again, with just the facts is, you can make the argument if you know the elements. Everyone clear? Any city has a responsibility if there's safety, like stoplights, safety, just whatever the hazards are in the city, they have to make sure that, A, they're conspicuous, which means visible, everyone clear? And that you can be aware of them. So you could make an argument if it was blended into the concrete, like you could tell, like a big bump, a concrete bump, which are those stops, versus the regular ground. It's plausible that you can make an argument saying they had a duty to make sure that it was visible at least, or conspicuous. Maybe not have like big, huge colors, but just some sort of ability to distinguish, you know, whatever the surroundings were from this concrete barrier. Did they breach, if you could claim that they breached their duty of care approximately, she didn't see it because it was not visible, it was not conspicuous, which caused her to trip and fall. Everyone clear? You can definitely make that argument. Again, it doesn't matter when they're trying to explain that she was there for a business thing, it doesn't matter. This is a city issue. Does that make sense? And the city owes that issue to everyone in the public using their roadways. Got it? It's not a specific higher duty. They owe a duty of care to everyone. The city does, because it's their concrete barriers. Everyone clear? Yes or no? All right, put a pause for a minute before we get into chapter 7. Any questions? All you know, the key here is literally just know the elements. Do you see what I'm saying? Every single time. And when you do, you're gonna be able to figure out the ending. Like for number 2 in chapter 6 about the market, it was pretty obvious. Does that make sense? Because it showed in the facts, the manager was aware of it but didn't notice. That's how the fact patterns are gonna be. You're not going to have to guess and have any contemplation. The facts will reveal the correct choice, but you have to get there. Got it? Someone just feeling really drab today? Because you're just like, just bummed out. You have like a week off.
I'm so excited.
Huh?
I'm excited.
You're excited to study?
Yes.
Good. Just feels so like, sad. That was so favorite.
Spending a long evening last night. That's exciting.
All right, let's take a look. We're going to the following page, chapter 7. Number 1 reads, Danny and Marion Klein were injured when part of a fireworks display went astray and exploded near them. They sued Pyrodyne Corp., the pyrotechnic company that was hired to set up and discharge the fireworks. The Kleins alleged, among other things, that the company should be strictly liable for the damages caused by the fireworks display. Will the court agree with the Kleins, and what factors will the court consider in making its decision discussfully? Okay, the only thing I had you learn about as far as abnormally dangerous activities that warrant strict liability is what? Explosives, fireworks, TNT. So this fits. So there are 3 areas that form the big unit of strict liability. One is abnormally dangerous actions or activities by the defendant, which the court clearly defines, and we'll talk about that to answer this first question. The second is wild animals, remember that? And lastly, we have strict product liability. But let's take a look at the first, which this is in reference to. Abnormally dangerous conditions. It says, what factors will the court consider in making its decision? Well, the court looks to many factors in order to determine whether an action by defendant or activity by defendant is considered strictly liable. They look at the degree of harm that exists even though the defendant would take all precautions to exercise reasonable care to protect people from getting hurt. If there's still a great deal of risk to potential plaintiffs, you know, they're gonna say, well, it's one of those activities, no matter who is performing it, it warrants that whether you or whoever you hire, it's gonna be one of those strict liability type of activities. Does that make sense? So obviously, I told you that firework displays are the number one, very easy to identify. The word dynamite, those are the factors that the court considers, and merely the fact that this happened, they will be strictly liable. Does that make sense? Remember, what does that mean? Liability without fault. Any questions? It reads, Jason Clark, an experienced hunter, bought a paintball gun. Clark practiced with the gun and knew how to screw in the carbon dioxide cartridge, pump the gun, and use its safety and trigger. Although Clark was aware that he could purchase protective eyewear, he chose not to buy it. Clark had taken gun safety courses and understood that it was, quote, common sense not to shoot anyone in the face. Clark's friend, Chris Wright, also owned a paintball gun and was similarly familiar with the gun's use and its risks. Clark Wright and their friends played a game that involved shooting paintballs at cars whose occupants also had the guns. One night while Clark and Wright were cruising with their guns, Wright shot at Clark's car, but hit Clark in the eye. Clark filed a product liability lawsuit against the manufacturer of Wright's paintball gun to recover for the injury. Clark claimed that the gun was defectively designed. During the trial, Wright testified that his gun never malfunctioned, in whose favor should the court ruling lie. This is a case of Dumb and Dumber, you know that. Okay. The bottom line, you're claiming that the gun was defectively designed for strict product liability. In order to recover for strict product liability, remember, when the gun was purchased, the defect had to exist in that gun when it left the defendant's hand, right? And then it couldn't change or substantially change its form or substance, or the product can't change in its utility. Does that make sense? Substantially. So if that defect existed, it was not modified or manipulated, and that defect in that product approximately caused harm to whatever plaintiff, you got a strict product liability lawsuit. But in the testimony here, it says his gun never malfunctioned. You can't claim defective design if the gun, you know, pull the trigger and it goes off. That's the purpose of it. Everyone clear? What we have here is someone, because they're upset that they got hurt, they're looking for some situation to make money. People do this all the time, but you're not gonna win in a strict product liability lawsuit. Everyone clear? Make sense? It doesn't show a defective design. And even if he said, let's leave the paper, they said, it didn't warn that you can't shoot it and it could hit someone in the eye and cause damage. That's called commonly known dangers associated with the product. Everyone clear? You could kill somebody with that. Any questions? You're gonna know it's strict product liability. Every Yahoo wants a claim, you know that? Because it's big money cases and they feel like if they can get one, they're rich. And it's kind of, you'll start seeing it as you've done going through these, especially number 3. This is crazy. All right, let's take a look. Young Tung Chow tried to unclog a floor drain in the kitchen of a restaurant where he worked. He used a drain cleaner called Lewis Red Devil Lye that contained crystalline sodium hydroxide. The product label said to wear eye protection, to put 1 tablespoon of lye directly into the drain, and to keep one space away from the drain because there could be dangerous backsplash. Without eye protection, Chow mixed 3 tablespoons of lye in a can and poured that mixture down the drain while bending over it. Everything they told you not to do, he just did. Does that make sense? Liquid splashed back into his face, causing injury. He brought a product liability suit based on inadequate warnings and design defect. The trial court granted summary judgment to the manufacturer and Chow appealed. An expert for Chow stated that the product was defective because it had a tendency to backslash. Is that a convincing argument? Why or why not? Okay. First of all, let's just talk about life itself. I can't believe I'm saying this, but you guys know. There are products that are gonna be dangerous. Why? Because it's intended to be dangerous because it can't unclog a grain. You don't sit there and just chug it, you know what I'm saying? It's like, there's things that will be harmful to you as a person, but you need them for the purpose that it's intended for. And that is why there were strict directions here. Does that make sense? So let's talk about the words though in this thing. It says, the trial court granted summary judgment to the manufacturer. You know what that means? There's no tribal issues here of that. They're gonna say, you win, manufacturer, this is a joke. Everyone clear? And of course, this Yahoo appealed, he wants it reviewed. He's like, I don't like what the court decided. Everyone clear? But he's not going to win on appeal because it's not a convincing argument, because there's products that have to be dangerous, but if you have warnings and you heeded the warnings, he'd have a different story if he actually wore eye protection. Everyone clear? He actually only put 1 tablespoon of lye directly into the drain, and he kept his face away from it. Everyone clear? And that still happened. Then you have a situation here that you potentially can sue for a strict product liability lawsuit. But he didn't follow the guidelines, and it warned a dangerous backlash, so it is not a convincing argument. Everyone clear?
Yes.
Let's take a look at 4. David D. bought a new Ford F-350 pickup truck. A year later, the truck spontaneously caught fire in Brony's driveway. The truck was destroyed, but no other property was damaged and no one was injured. D filed suit in Nebraska State Court against Ford Motor Company on a theory of strict product liability to recover the cost of the truck. Nebraska limits the application of strict product liability to situations involving personal injuries. Is D's claim likely to succeed? Why or why not? Is there another basis for liability in which he might recover his claim? Okay, this is a situation where if the law is in place, there was no personal injury here, folks. So he wants economic damages. It's called federal preemption, when the government steps in and says, we're not gonna warrant this law unless this happens. And it makes sense because you can recover the same amount filing negligence. Everyone clear? Yes or no? As long as there's a way out for you to recover for that, you're fine. And that's just like government regulates certain industries based on certain things that happen. Obviously, if there was personal injury here, you would be able to file a strict product liability lawsuit. Does that make sense? But if not, you would still be able to recover for the economic damages for the loss of the truck. You can't do it through strict liability, but you could easily do it through a breach of contract theory, which we haven't studied yet, as well as through negligence, very easily. Everyone clear? Just when the government regulates industry and limits things. Does that make sense? Number 5, which is a very sad case in the jury's, the plaintiff's lawyer is thinking that you're gonna cry and give money to the plaintiff because of this case. It's a tough case because you have a bad result, but a lot, so you know, in litigation, especially civil litigation, it's a balancing act, because even though, for example, a defendant is innocent, they still pay out because it's not worth the money paid for the lawyers to defend saying you didn't do it, and that's what a lot of plaintiffs are banking for, just so you know. They want the wow factor, sympathy factor, and that's why I cannot emphasize enough, stay out of court. It's the truth. And I don't think enough people can absorb that. But I'm telling you, it is not cheap and it's emotionally tormenting. All right, let's look at 5. 5-year-old Cheyenne Stark was riding in the backseat of her parents' Ford Taurus. She's 5, okay? Cheyenne was not sitting in a booster seat. Instead, she was using a seatbelt designed by Ford, but was wearing the shoulder belt behind her back. The car was involved in a collision. As a result, Cheyenne suffered a spinal cord injury and was paralyzed from the waist down. The family filed a suit against Ford Motor Company alleging that the seat belt was defectively designed, Could Ford successfully claim that Cheyenne had misused the seatbelt? Why or why not? No, okay? Here's another situation. This is product misuse based on the plaintiff's product's misuse. Everyone clear? This is absolutely ridiculous. First of all, you're never gonna, the thing is, this was in court because you've got a kid that's paralyzed. All you're doing is showing the kid that's paralyzed and saying, Ford has big money, please pay for this. But it's really parents just feeling ultra guilty that they screwed up their kid. Does that make sense? Because you were too lazy to put the kid in the proper booster chair seat. I don't know if you've ever taken a DMV test, like under 12, there's certain restrictions for every age under 12. And when you're 5, you need to be in a booster seat. I mean, got my great nieces and nephews staying with me. Man, I forget those days. My kids are your age. I was like, huh? Like you need so much stuff to take a little person from A to B. You know that? But bottom line, they didn't do that. But more importantly, the seatbelt wasn't defective. It's not meant like, when you have a seatbelt like this, you put it on, if you did this, that's you. It's not the seatbelt. Everyone clear? You understand that? That's product misuse. You can't, you're not gonna win on that, sadly. I bet though, they made a payday, because they probably settled out of court for a bunch of money, because that's what people do, to just make you sweat and pay for their own stupidity, sadly. Does that make sense? All right. Let's look, any questions?
Okay, so, it says Ford could successfully claim that Cheyenne had misused the seatbelt? No.
That's not, I'm telling you the law, the actual law. This is in front of the jury, that's what I was just saying. Juries are gonna pay out, because they see a girl that's paralyzed, and they're gonna say, Ford has the money to pay out. We don't know what's all transpired in the opening and closing arguments and evidentiary. They take pieces of a case, and the ultimate decision of the case doesn't affect this actual question. Does that make sense? So, you can't, the law isn't like, I'm just explaining the law. When you're in court, even though someone's guilty of negligence, if I was a lawyer, they're not guilty. Do you see what I'm saying? We're not worried about the actual outcome. I'm explaining what you gotta do and why you should stay out of court, because this is product misuse based on common sense and looking at what's going on here. They haven't thought, but what did I say? They're probably gonna win. Does that make sense? Why? Because you can manipulate anything in the court of law. Got it? That's what I'm saying, yes.
Can they argue that Ford could have predicted the
No. There's laws with kids that are 5. Where's the booster chair? Does that make sense? There's a reason you have proper seats for kids under 12. Because it prevents kids from doing exactly what this kid is doing. The seatbelt is not defective, Sarah. Riley,
What would this look like? How would I answer this in my rock format?
we're not gonna do, you can see me after class
Okay.
in 18, in law 19.
Okay.
Does that make sense?
Yeah. So I was trying to think it through it. I have no
Do you
clue.
see why it's interesting to take both classes together?
Yeah.
Because it really helps you facilitate to get the right answers here.
Yeah, for sure.
That's for someone who's double dipping in both classes, and I love that, Riley. I like that your mind's
Sorry.
like that. No, don't apologize for that. I love it. Please notice, when you see cases, it's not the actual decision by your peers of jurors. I'm just telling you what the law states, and I don't know what the attorneys are doing. Does that make sense? So they just take pieces to teach you that this is what goes on in life. Any other questions? We're here to teach you the elements of how to establish absolutely these foundational areas. Does that make sense? And the defense, that's all I'm asking you to do. But we are definitely not gonna be the jurors in a case that we don't know what the arguments are. But that's why in civil court, especially with negligence and all this stuff, like I've gone in, I feel like I don't have a pot to piss in. So, I mean, I'm like, this case sucks, but it was assigned to me, I worked for a big firm, you know? I was like, and I walked out, we're winners. And I was like, I was like, these people are just, I mean, I I've got a piece of land somewhere, you know, off the coast, of wherever. You can just sell what it's just gross what people are willing to suck in and buy into, because they don't know the law. The law is given to them by the judge, but the lawyers are manipulating the facts. Whoever you believe is going to be the winner. Does that make it legally correct? No, you get tried by your peers. That's why it's, remember what I told you about the case with the accident with Larry Monshemp going up to a trial? The drug dealer way back when, soccer mommy, he was going past the light. But if you believe people, doesn't make it right, it just is the system. Everyone clear? So what you wanna do is avoid the system, or make sure you have a very clever lawyer. Does that make sense? If it's not, it is really sad. It makes me so happy that I'm not doing it anymore. It used to just drive me insane. So I was like, I really don't like my client, we should totally lose what we're gonna win. Cause I just found a loophole, I found a little lane, and I'm gonna work it, cause that's what I do. And we're winners, and I'm just like, all in a day's work, you know? You feel sick, you know? There's a lot that I feel good about, but then there's some that you're just like, I really wish that we would've went against us. But, the lawyer just uses the law, and you can manipulate it if you know the law. But you are not here to manipulate the law, you're here to what? Learn it, which is good. All right, product liability. Here we go again. I really wish I liked it. All right, number 7. Medix Pharmaceutical Corp makes Solidyne, a prescription oral antibiotic. Medix warns physicians that autoimmune syndromes, including drug-induced lupus-like syndrome, may be associated with the use of a drug. Amanda Watts had chronic acne. Her physician prescribed Solidyne. Information included with the drug did not mention the risk of autoimmune disorders, and Watts was not otherwise advised of it. She was prescribed the drug twice, each time for 20 weeks. Later, she experienced debilitating joint pain, and after being hospitalized, was diagnosed with lupus. On what basis could Watts recover from Medix in an action grounded in product liability? Explain. This is a pretty easy one. She's gonna be a winner, sadly. She has lupus. Why? Because here, the defect existed in the product because there was no warning. Everyone clear? So it says this, Medix warns physicians that autoimmune syndromes, including drug-induced lupus, may be associated with the use of the drug. And it says, information included with the drug keywords here did not mention the risk. Does that make sense of this? That's the key. If you're gonna win on strict product liability, it's all about the product and not the doctor. Everyone clear? But in a case like this, you're gonna win because there was no warning. You'll win for strict liability, but you should also sue for negligence in the doctor because he had a duty of care to warn his patient that this could happen. Does that make sense? And the doctor failed to warn the patient that you could have this lupus syndrome. And is it foreseeable if you don't know the risk of the drug associated with what could happen? And this was an associated risk. She got hurt because she didn't know about it. Does that make sense? So you can see how you can attack it through negligence as well as strict product liability. Got it? And what's the defect here? That there was no warning. That is also considered a defect in a product. Got it? Any questions?
Could you go over 7.6?
Which one?
7.6. I think you just did.
Oh, I did, sorry.
No, it's
Thank you.
okay. But I
Didn't realize I jumped it. Okay, we're doing 6 and then 8. Let's go to number 6. While driving on Interstate 40 in North Carolina, Carol Jett became distracted by a texting system in the cab of his tractor-trailer truck. He smashed into several vehicles that were slowed or stopped in front of him, injuring Barbara and Michael Dirk and others. The injured motorists filed a suit in a federal district court against Geologic Solutions, the maker of the texting system, alleging product liability. Was the accident caused by Jett's inattention or the texting device? Should a manufacturer be required to design a product that is incapable of distracting a driver discussed? This is laughable at best, okay? They have TVs in the front seat now. Do you see what I'm getting at? They've got all sorts of people, bottom line, your responsibility of a driver is to pay attention just by anybody. There could be someone on the seat going, let's help, do one of these. What are you gonna do? People are talking to you, a good song comes on, I don't know where your mind goes. Everyone clear? It's not, the texting device didn't say it was not working fine, it was working, it was doing its job. Same with your phone when you receive a text. Does that mean that you should be staring at it? Does that make sense? So you're not gonna win on a strict product liability lawsuit here just because you were inattentive because something occurred. It's like a good song goes on, you're gonna sue the the person that wrote that song because it's so good that you didn't pay attention to the road. Do you see what I'm getting at? Or a great conversation that the passenger's telling you that you look back and you're like, wow, I got distracted, you should know how to talk to me. Does that make, it's like, these are the kind of cases that drive people nuts because you can see what they do. They get into an accident, it's their own doggone fault, but they wanted someone to pay for it. You see this all the time, every day, all day. Does that make sense? And the letter of the law, not talking about what ultimately could happen, which I'm not the attorneys, we don't know what the arguments are, but as far as the question, it says, was the accident caused by his inattention or the texting device? There's nothing to indicate that the texting device is defective or faulty, but it definitely shows that he was not attentive. So, and it says, it's just, should a manufacturer be required to design a product that is incapable of distracting a driver? That's called, you have to pump out a person with a normal brain, so I don't think it's possible. Everyone clear? Last but not least, in chapter 7, let's look at problem 8. Duval Ford sold Amy Ford at 250 pickup truck to David Sweat, I don't know. Before taking delivery, Sweat ordered a lift kit to be installed on the truck by a Duval subcontractor. Sweat also replaced the tires and modify the suspension system to increase the towing capacity. Later through Birkins Chevrolet, Sweat sold the truck to Sean Lesnick. Sweat had no problems with the truck's steering or suspension, but Lesnick did. Yet the steering repaired and made additional changes, including installing a steering stabilizer and replacing the tires. 2 months later, Lesnick was driving the truck when the steering and suspension suddenly failed and the truck flipped over, causing Lesnick severe injuries. Could Lesnick successfully claim that Duval and Birkins failed to warn him of the risk of a lifted truck? Explain. Absolutely not. Okay. Bottom line, you bought the truck and then you screwed it, screwed it up with the suspension system, manipulated it. Once you touched it and did that kind of modification, you can't go back to the people that sold it to you and say you screwed up. Does that make sense? You touched it, it's now tainted. You manipulated it. Everyone clear? You can't say to people after you've manipulated a product that they then breached their duty after you got hurt, after you manipulated it. Once you modify something, it's very challenging. Does that make sense? Period. You're not gonna win on negligence and or strict product liability. The minute it's been substantially changed, it's not gonna work. Everyone clear? That's what, think about that. There is, you can't claim it's someone else's fault after you substantially modified it. Got it? Any questions before I do another review for chapters, any questions from chapter 2, the questions that we've done, chapter 6 or 7? Eli?
It's not specifically in those chapters, but I just want to know what vocabulary you use from chapter 2. So there's a lot of words, and it's only the ones like plaintiff and I'm just wondering.
Well, I've just explained summary judgment. There's things about a complaint. It's just all the vocabulary that's already been introduced in chapters 6 and 7. They define it in chapter 3. These are all the questions in chapter 6 and 7. They define those words, and those are the ones that will be utilized. If you can get through the homework in chapters 2, 6, and 7 successfully, and what I lecture on, that's all I'm using. Okay. Sarah? hear you. Can you hear her? Please use your loud voice, because I can't hear you.
How do you use for like applied design defects?
Design defect, that's just, they're just looking at defects in products. They could take a defective product, for example, let's say that there is a product that could be made safer, but let's say that a design defect is warning. Like it could be a defective product because there's not a proper warning. That's a defective design because it should have had a warning. Or maybe something didn't close properly, that if it closed, it took off your finger. Does that make sense? And it could have been made safer because you could have put a rubber stop on it. I mean, there's multiple ways. Like for product liability to exist, you have to have a defect in the product. Does that make sense? That's just one of many things that they could claim is a defective product. It could be a duty to warn. It could be, there's not a proper I don't know, could be anything in a product. Like you open a computer, electrocutes you. Does that make sense? That's a design defect. Computer should not electrocute you the minute you open it. Does that make, you see what I'm saying? Does that make sense? Okay. What else? What about any questions I'm gonna entertain from chapter 2? It's your dime, people. What do you need? Anything from, any explanation of any torts, negligence?
I have a question.
Aranza, right?
Yes. About what are the defenses of negligence?
Okay.
Superseding causes.
Superseding causes, okay. We're talking about the tort of negligence. When we look at superseding causes, it's really third, like unforeseen third, like I just say third party, but it's like events, third party events or actions that break the chain of causation between foreseeable cause and the type of harm the plaintiff suffered. Let's just go back to the construction company, like where you didn't wear a hard hat. Let's say you're on the construction site without that hard hat on, right? A superseding cause could be kids outside the construction zone chucking rocks into the construction site and hitting you on the head, okay? You're supposed to wear the hard hat to protect you from falling scaffold. So the company will not be liable because it's unforeseen that you wear a hard hat to protect you from kids chucking rocks at you outside the gate of the area. Does that make sense?
Yeah.
Or a superseding cause could be lightning striking the tree that hits you in the head and you don't have a hard hat on. Does that make sense? Yes, the bridge probably, your head would have been a little better in both cases if you had a hard hat on, but the purpose of wearing a hard hat is not to protect you from lightning striking trees, and it's not there to protect you from kids whipping rocks outside the construction zone. So do you see that, it breaks that chain of foreseeability to the type of harm the plaintiff suffered. Does that make sense? What do you got, people? Let's have it. Any explanations of any tort law, any system, state and federal, any processes, any requirements?
Can you go over what?
Your Matthew?
Yes. So you give me, like, define what disparagement of property is?
Sure. Disparagement of property is, these are personal property torts. Now, you know what defamation is, right? A defamator, when you're like making a false statement of a fact, which is published about a person and it causes that person to suffer damages to their reputation. Disparagement of property is really when you say, for example, pick a product. Clorox bleach cannot take out a grass stain. If you verbally say that and publish it, but Clorox bleach can actually take out that grass stain, you're making false statements about a product, true? And if it's a false statement about a product which is published, and the owner of Clorox bleach can show that they suffered economic loss, and there was no truth to the statement or any type of absolute, absolute or qualified privilege based on that statement being published, then if it's verbally made, it's called slander of quality. If it's in the permanent form, it's called trade libel. Does that make sense?
Can we go over assault and battery?
I sure will. The tort of assault, again, let's take a look at torts against the person. Every single intentional tort against the person, and just as far as intentional torts in general, need that first requirement, which is probably the most interesting to lock in your head so you don't get mixed up on a test, which is intentional conduct by the defendant. Remember, that requirement is absolutely necessary for the intentional torts. Whether the defendant premeditated, meant to do it, thought about it, or not, is irrelevant. It's the action that that defendant sets in motion. Whatever action the defendant has, that action, or if the defendant sets something into motion, that action, whether it's meant to happen or not, if there was some sort of attachment with the defendant, that action has a resulting consequence. Remember, I could be talking and not meaning to, John, hit Isaac, but if I do, even though it's an accident, it's still intentional conduct as far as intentional torts is concerned. So with an assault, think about this. It's intentional conduct by the defendant, whether the defendant meant to do it or not. If that intentional conduct by the defendant created in the plaintiff awareness, right, of an immediate, harmful, or offensive contact, you've got an assault, okay? But you want to make sure if that occurred, there was no consent by the plaintiff for some sort of like harmful or offensive activity. Does that make sense? It's like, I agree to play tackle football and I'm crying that I got assaulted. Well, that's part of the game. You can't cry assault if you give consent to an activity like that. And then if the defendant, if you're as the plaintiff trying to use reasonably necessary force to protect your property, it's justified. Does that make sense? Or if you had to use deadly force because it was first provoked against you for the protection of your life or the life of another. Got it? So that's the tort of assault. So evaluate it in those terms, because think about it. If you did agree to play tackle football and then after someone tackles you and you go, I'm gonna sue you for assault, it doesn't exist. Think about that. These are the torts where the defense does work against the elements. Got that? Then we take a look at the tort of battery. Once again, think about the conduct, intentional conduct by the defendant, right? So whatever that is, you set it into motion, you didn't mean to happen, you meant it to happen, whatever it is, that conduct defendant had a consequence. Intentional conduct by the defendant, but this time it has to have contact, right? Did I say you have to be aware of it? No. Okay, so you have to have that contact of a harmful or offensive nature. Got it? Then you have a battery. Same defenses apply. You need, if you give consent to something that's harmful or offensive, there's no battery. Reasonably necessary force to protect property, and deadly force if you're left to the left of another's been threatened first. Got it? Does that make sense?
Yeah, that's thank you.
What else? Sarah?
Explain the feature contract, the feature contract.
We're gonna learn, we don't even have contracts yet.
Good. I think you mentioned it in chapter 6 or 3.
I said, we're gonna learn about it, but that's one theory for strict product liability under warranty, but we're gonna learn contracts in our next unit. We're gonna spend a lot of time there. All right,
What's the difference between arbitration inside information and privacy and trust of
a big difference, because one is against the person and the other is on real property. Okay, so trespass to land, as the name suggests, it's based on real property. Is if you are intentionally, as a defendant, entering onto a plaintiff's property, the real land, the land, without their permission, it's actionable. Versus intrusion into a plaintiff's private affairs and seclusion, it's personal against the plaintiff. You're looking at the plaintiff. You're violating the plaintiff's solitude. You're trying to take the plaintiff. You're trying to be a peeping Tom to take a look at the plaintiff. But just so you open the door, Ronza, you could definitely have invasion of privacy along with trespass to the lift. Does that make sense? Does that make, you see the person versus the lift?
Yeah,
Okay. Everyone's so glum today. Hmm? You don't know? Always a good day, right?
Yes,
Appreciate living people.
I do.
I don't know, it's weird, but I'm literally that person. I'm in a good mood every day I wake up. I think I've just told him that I'm not really good mood. Appreciate that. Okay, so take a look at the board. Have a lot of time to prepare. Oh, I should put up there, we do have a business club meeting today. Just please come by in this room, 12 to 1. It's never the full time right now. We're just getting it going. Stop by, check it out. Love to have you guys there. I do have office hours today from 2:30 to 3:30. If you think of anything, that is an opportunity to see me before the exam, as well as, we're not gonna have a meeting next Tuesday, 12 to 1 next Tuesday. I will substitute my business club hours and give you next day. Oh, good, no, I won't work with you. So you come work in my first class. So it's today, 2:30 to 3:30, if you have additional questions. Have a great day. No attendance today.
That's it.
Yeah.
Yay.